drinking.
Alcohol.
He was intoxicated.
And,
We were not together.
okay, you heard him testify. I questioned him about that he had he was,
I became pregnant. Things just kind of escalated very quickly. He became very controlling. You know, like down to what I was supposed to eat that day. There was one instance where I ate 3 of his eggs, and
3 of his eggs?
3 of his eggs from his refrigerator, even though I was to buy him groceries when I would go visit. And he wanted me to reimburse him for the 3 eggs that I ate that day, and told me that I was supposed to eat fish that day instead of eggs. Became very angry.
or were you being?
I would go back during my work week at the time. I would go back to my home. Sometimes I would park my RV in my driveway and sleep in my RV.
Okay, you had a home where?
Yes, in Coleman, Alabama.
Coleman, Alabama. And what is your occupation?
Nurse practitioner.
Okay. And at the time when you and Ms. Wiley reconnected, where were you working?
Talladega at Citizens Baptist Medical Center.
Okay. And what hours were you working?
6 p.m. to 6 a.m., I believe,
Okay. And where did Mr. Wiley live?
in Enterprise, Alabama.
And so the distance between Coleman and Enterprise is how far?
5 hours, maybe 4 hours.
Okay.
Yeah.
And again, going to law school in Alabama. He's in Lower Alabama.
Wait, they have a law school in Alabama?
They do, amazingly, and they actually teach the law. But you do have to declare your loyalty to either Alabama or Auburn as you cross the line.
Thank you for that.
Yes. But again, you were living in Coleman, which is in North Alabama, correct?
Yes.
Enterprise is in, as we say in LA, Lower Alabama.
Yes.
And so there was a travel distance between the two.
Yes.
He was still in the military at the time, is that correct?
Yes.
And so when you would go to visit him, you would just carry your RV down there.
Correct. Yes.
And how often were y'all seeing one another?
Probably every other week on my off weeks for about 3 months.
Because you would work
7
3/12?
days in a row. And
How many- how long?
7 shifts on and then 7
week
days
off.
off. Yes.
Okay, so you would work 7/12s and then you would be off and you would go and travel to see him? Is that
Yes.
correct? And he was working more of a Monday through Friday job with the military at that point in
Yes.
time, is that
Correct.
right?
Yes.
How did your relationship end? Did y'all just say we're done and break up?
Yeah. We kind of went back and forth for a couple of weeks thereafter. I went down there. I was trying to establish a doctor down there in Enterprise so that he could be involved in the pregnancy. And I went down there. The last time I remember going down there was to go to the doctor's appointment, and I was begging him to go with me. And he did end up going. It was a nurse visit. It wasn't with the doctor. But then, everything escalated from there, and I don't know what exactly, we just kept arguing and arguing, and so eventually we just parted ways.
So at what point of your pregnancy did yours and Mr. Wiley's relationship end?
As soon as I got pregnant, the first month, in July.
Okay, in July?
Or, I'm sorry, in June to July. Yeah.
Okay. And so you quit going down there
Yes,
and established your prenatal care where?
at Vanderbilt in Nashville.
Okay. Now, are you from this area? I know you
Yes, ma'am.
previously testified again when you were called by his attorney that you're from this area and you have family in this area. Is
Yes,
that correct?
correct.
And were you relocating and were you intending to move up here and to found a home? And you did in fact do that, is that correct?
Yes,
For a
yes.
period of time during your pregnancy and afterwards, did you still maintain your professional credentials in Alabama?
Oh, yeah, yeah.
And did you have any other source of income other than
No,
did you have a pregnancy rider? Was pregnancy covered under your health insurance?
they covered my pregnancy visits, but my job changed, like another employer took over right before I delivered, like a couple months before, and I had to change insurances It was a big mess, but it was covered, yes.
Did Mr. Wiley reach out during the pregnancy time? Or did you reach out to him?
When I would go to ultrasound visits, which was quite frequently, I would send him updates on how the pregnancy was progressing.
And did you send that via text message?
Yes, correct.
Okay. And as a result, did you have any out-of-pocket medical expenses during your pregnancy that you ever requested that Mr. Wiley pay?
I did have out-of-pocket medical expenses for me and Anna Claire, but no, I did not give those to him.
Okay. And did he ever offer or say, how much can I contribute to the prenatal care?
I don't believe so.
Okay. Now, who was your doctor?
Gosh, I'd have to. It was a nurse practitioner that I was seeing at the Vanderbilt High Risk Clinic. I can't remember her name at this point. I don't remember her name.
All right. And then did you have a normal pregnancy and birth process?
It was high risk. I had gestational diabetes during my pregnancy, and I had to take insulin, and
If you don't mind me asking, how old were you when you discovered you were pregnant?
39.
And you had not had a child prior?
No, ma'am.
And as a result, at 39, just your age-wise,
That,
it started out with a high-risk pregnancy?
yes, ma'am, because I was considered older.
Okay. And at the point in time, and you covered all your expenses, and then when you went into labor, did you reach out and contact him?
Yes, before I went into labor, I contacted him to try to arrange how we were going to, get him up there. And I had said, just let us contact you closer to delivery because I didn't know how long it would take. I was being induced.
And again, now, I mean, with you being 39 at the time, did you go into labor, or were you scheduled and be induced?
I was scheduled to be induced.
Okay.
Yes.
And so you didn't, you had that scheduled, but you didn't go into labor before that time?
No.
So when you scheduled that, did you let him know?
Yes.
In how long a period of time was it that you said, hey, I'm going in on Thursday? Did you give him Wednesday's notice, or was it several days, several weeks?
Just several weeks.
Okay. So he had an arrangement to schedule to be able to be here,
Yes.
absent you going into early labor?
Yes.
That you did not do? Okay. Was he present at the time of the birth of Anna Claire?
He was at the hospital. He wasn't, I had a C-section. My mom was in the room with us.
But he was present there at the time that not necessarily in the room, but she was present at the hospital, and he was able to see the child
Yes.
shortly after her birth. Is that correct?
Yes.
And how long a time did he stay at the hospital?
For 1 hour.
For 1 hour. And I believe Anna Claire was born on January 16th of 2022. Is that correct?
Yes, ma'am.
And you had given him several weeks' notice.
Yes.
Were you, again, in was it a long, drawn-out labor?
It was. I went in on a Friday to be induced, and I delivered Sunday around lunchtime. I was in labor for 2 days.
So 2 days. And do you
Yes.
know, was he there the full 2 days?
I believe so.
Okay.
He
So
came
again,
early.
anticipating that it possibly would have been a quicker birth, he only saw her for an hour.
Yes.
And do you know did he leave and go back to Alabama at that point in time?
Yes.
Did you have contact with him in the hospital?
Yes.
And how did he present in the hospital on January 16th of 2022?
He smelled of alcohol during his hospital visit with her during the hour that he was there.
So again, he had been there for a couple of days.
Yes.
But when he came in to actually meet his daughter for the first time, was there any issues?
We were in the hospital for, I think, 5 days total. Yeah.
Okay. And came home, and during that period of time, did you send photos and different things to him?
Oh, yeah.
Keeping him updated?
Yes.
Were y'all communicating back and forth at that point in time via text message?
Yes, ma'am.
And did you try to include him and keep him informed about the progress of your daughter?
Yes, ma'am.
Were there arrangements made for him to come and to actually again visit on, I think it was March 5th through the 8th?
Yes.
And did he in fact come?
I think he was supposed to come in February, and he canceled in February. He said he was sick, but then he later said he was hungover.
Okay. But the first time he came, even though, and we'll get it, I've got the whole, we're going to introduce all these text messages and things. You had communicated, and invited him up on other occasions, but it's solidified and he was able to come up on
Yes,
March 5th through the
correct.
8th. Is
Yes,
that
ma'am.
correct? Did you offer for him to come into your home and
Yes.
stay there with the child so he would
Yes.
have bonding time?
Yes.
And did he in fact do that?
Yes.
And how did the March 5th through 8th process go when he was there?
Gosh, I don't,
Again, she's a month and a half old at the time. And did he tend to her? Were you breastfeeding?
yes, I was.
Okay. Did he help out with her, change diapers, do things like that? And
Yeah, he changed diapers.
nothing unusual transpired that first meeting, did there?
There's unusual things that happen, but I don't remember exact dates of when those things happened.
Okay. Later on in the month, did he come back with both his son and his daughter to meet their half-sibling?
Yes.
And were they on March 20th through 21st? Did you invite them and his daughter Ashley and his son
Mark.
Mark?
Yes.
Did they come into the home and stay
Yes.
in your home?
Yes, ma'am.
So that they could meet their sibling?
Yes, ma'am.
And was that a remarkable or an unremarkable, just a normal?
It was just an overnight visit, one night, yeah.
Okay. Then again, on April 26th through the 28th, did he come back alone and visit with the child and stay in your home?
Yes.
Okay. Then was there a significant lapse of time up until December when he came back to visit?
Yes, and he went about 7 months before he came back again.
But you had communicated and talked and done everything, keeping him updated and posted, is that
Yeah.
correct?
Yes, ma'am.
During that period of time, did you receive calls from him at what I would call inappropriate hours, especially because you have a young child in your home?
Oh, yeah.
What would happen through that period of time?
He would randomly text at 2, 3, 1 o'clock in the morning, just conflicting, demeaning comments and such.
Okay. When you would see those, would you ask him to not? And in your understanding, been possibly under the influence when he's called?
Oh, yes.
About how many occasions has that happened?
There's been at least 2 videos with Annie Clear that he's appeared intoxicated, highly
Again,
intoxicated.
we have, if necessary, we have there's FaceTime, is that correct?
Correct, yes.
Okay. How does he act when he is? Some people are happy drunks, some people are mean drunks, some people are sleepy drunks.
I mean, he can be both, but during those videos, I think he was just very, I don't know, erratic, and he would, I don't know, one time he said I was a bad mom because I was keeping her from him. But then, just talking about her, you look just like me, just very loud and just very loud, slurring his words and such.
Now, so in 2022, he saw her 4 times over an hour on the date of her birth, 5th through the 8th, March 20th and 21st, April 26th and 28th, and then December 1st and 2nd. Is that
Yes, ma'am.
correct? And all those occasions, you offered your home up and allowed him to stay there. Is that correct?
He stayed there the first 2 visits, I believe, and then after that, he started getting a hotel.
Hotel room, but he would
Yes.
come and visit in your home.
Correct.
Is that right?
Yeah.
Okay. The lawsuit was filed to establish paternity. Is that correct?
Yes, ma'am.
And we were scheduled to come to court, I believe, July 5th, and he requested a DNA test. Is that correct?
Yes, ma'am.
Was there ever a question in your mind who the father of this child was?
Absolutely not.
But when he requested it, we consented and said, sure, we'll have one. Is that right?
Yes.
And did he reach out to you before that? That hearing was scheduled for several weeks. Had he reached out to you and advised when he was coming and tried to schedule a time to visit with Miss Anna Claire?
No.
Okay. After we came to court, we arranged a DNA testing. Did y'all meet and do the DNA testing?
Yes.
Did you carry y'all's daughter with him and meet with him so he would have chance to interact with your child?
Yes, we met at a Starbucks
Okay.
after the DNA test.
Did you offer additional time if he was going to stay around?
I can't remember. I'd have to look at the
But
text.
right after the DNA test, did he state that I've got to get back on the road, I'm leaving?
Yes.
He came in February, on the 23rd and the 25th of February to visit, is that correct?
Yes.
And during that period of time that he was visiting, did he get a hotel room?
This February? Yes.
February 23.
Yeah. Oh, 23.
We're in 24 now, so when you said this.
Yeah, he got a hotel room.
Okay. And in fact, did he fall asleep during his visits with his daughter?
Yes. 2 separate occasions.
He came back in May.
Actually, sometimes I'm in the room with them, but a lot of times I'm in the kitchen cooking, making breakfast, making lunch.
For Anna Claire and you, or for all of you?
I let him eat too, because
Okay,
usually
you
there's
just-
a large amount, yeah.
So
But
on,
it's for the purpose for Anna Claire.
right, but again, you make enough that he can enjoy a meal with his daughter and y'all can sit down and have dinner or lunch or whatever the time frame, is that correct?
Yes, ma'am.
Okay, and during that May 18th through the 21st, was there an occasion that he fell asleep again?
Yes.
And what happened to Anna Claire when he was supposed to be watching her?
She climbed up on a chair and fell down.
Okay. Was he there supposed to be playing with her and watching her?
Yeah, they were in the adjacent room playing, and he laid down on the couch like he was going to go to sleep, and she climbed up on a chair and fell. I was in the kitchen cooking, heard her crying. I think that was in the afternoon, so like he would come like 8 to 10 or until she went down for a nap, and then he would come back after a nap. I think that was in the afternoon, probably mid-visit.
Okay. Then was there a 6 months hiatus when he did not come again?
Yes, ma'am.
Did he come and see November 7th through the 11th?
Yes.
And again, was there anything remarkable about that visit?
I think that's when he fell asleep again, the second time.
Okay. And then in February of this year, he came again, is that right?
Yes.
And again, is this another vision when he comes to visit with his daughter that he either lays down on the floor or lays out on the couch and goes to sleep?
Yes, while playing with her.
Okay. Falling asleep, is he just pulling into your driveway and after an 8-hour drive, sometimes 9, depending on traffic, and I'm exhausted, I need to lay down, or is it the next day and the day after?
No, it's in the middle of his visit
Okay.
with her.
Have you smelt alcohol on him when he's come to your house to visit?
No.
Just at the hospital, is
Yes,
that
ma'am.
correct? Now, you completed and we filed it with the court, but if I could. Is that correct?
Yes, ma'am.
Is that a copy of your certificate?
Yes.
Your Honorable Member?
Oh, that according to my exhibit 11.
Now, after Anna Claire was born, do you know whether or not he enrolled her in, I believe he's at the military at TRICARE?
Yes.
And
No,
do you
he
have a
didn't.
card with TRICARE?
No.
To your knowledge, has he ever enrolled her in TRICARE?
No.
We appeared in court, did the DNA testing to put any question in his mind about the paternity. And after that, and that would have been January of 2023, a year and at least 5 months ago, since that time that he has definitively been established as the father, has he given you any type of insurance card in 2024?
Since mediation,
Okay.
June of 2023 was the first check.
Since June of 2023, when we were not successful in mediation.
Correct, yes.
You received 2 separate checks.
3 separate checks.
3 separate
Since then,
checks totaling how much?
2,000 or 1,800, somewhere around there.
Okay.
No more than 2,000.
But nothing further.
No, ma'am.
Has he inquired about any medical expenses that Anna Claire would have?
I can't remember if he has or not. I don't.
But
I
you
mean,
haven't
not
sent him
that I
any
remember.
bills?
No.
Okay. Do you have health insurance coverage on her?
Yes, ma'am.
And who do you have that through?
Blue Cross Blue Shield.
And is that through your employer or is it a private pay?
It's private.
And how much do you pay for her health insurance?
It's for both of us. It's for health and dental and everything. It's about $700 a month.
Okay. What do you do for a living now, ma'am?
Nurse practitioner.
And where do you work?
Horizon Medical Center and Nashville General ER and Centennial Medical Center.
And are you what in the business work on a PRN basis?
Yes, ma'am.
And can you set your own schedule?
Yes, ma'am.
And again, you testified to this prior. How often are you working?
6 to 8 shifts per month.
And when you say shift, that's a day.
There are various hours, so some of the hospitals have 6-hour shifts, 8-hour shifts, 9-hour shifts, 11-hour shifts. It just depends what I sign up for.
But when you're talking about a shift, again, with a healthcare worker and somebody in a hospital setting, a shift may be, I want to define it, a shift may be I'm working 7-day, 12 hours. That's a shift. So when you say 6 times, you said 6 to what?
6 to 8 shifts per month
But
on average.
I'm saying that equates, you're working 6 to 8 days a month.
Yes, correct.
Okay, you're not taking a shift that is a weekend
No, ma'am.
shift
No, ma'am.
where you're not leaving the hospital for 36
No.
hours.
No.
A shift that you're referring, you are actually working anywhere from 6 to 8 days a
Per month.
month.
Yes,
Is that right?
that's right, yes.
Now, the court asked us previously, and I think I provided a copy, you want another copy? It's her income information. You got it. Pursuant to the court's request the last time we were here, he asked to produce your records and your records from your earnings. And did you do that?
Yes, ma'am.
And first attached onto the top of the notice of filing, is this a paycheck stub
Yes,
that you have?
correct.
And the first one I think we have is, it's from Burton Hills, and it is, what is this one from?
This is Envision Healthcare. That's the Centennial and Horizon Medical Center.
So this is through the HCA type?
Yes.
Okay.
HCA actually just took over, but yeah.
And then the Hospital Physician Services SE,
Yes, that's through Team Health. It's, that's the Nashville General ER.
that's the ER shift that you
Yes.
work. And then you have produced your tax returns for 2020, that you filed for 2023.
Yes, ma'am.
And have you had the shift that you're working basically through 2023?
I started doing PRN in October of 2023.
2023. And so, and prior to doing that shift, what were you working?
I was doing a full-time job, 7 shifts on, 7 shifts off.
Okay. And that would have been through APOGE Medical Group,
Yes, ma'am.
and you made $103,000 with them.
Yes,
And then with the Tennessee IPS Medical Services Marathon Inpatient, you made $5,736.24. So 2023, you had an income of $117,000 gross. Is that correct?
yes, ma'am.
What were your capital gains? You had some capital gains income at that point in time. Did you sell some property or do something?
I sold my house in Alabama.
In Alabama?
Yeah,
And that was a one-time sale. Is that correct?
yes, ma'am.
Okay. And you've produced the entirety of your 2023 tax return, is that correct?
Yes, ma'am.
You also have produced for us your 2022 federal tax return. Is that
Yes.
right?
Yes, ma'am.
And at that point in time, were you working, and including your W-2s, did you work for Ameriteam Services and make some $58,000 with them?
Yes.
And APO GEE Medical Group, again, made $32,000 with them, is that right?
Yes.
And so your gross income for 2022 was $91,479, is that right?
Yes.
And pursuant to the court's instructions, you have produced your current pay and both full tax returns with attachments, is that
Yes.
right?
Yes, ma'am.
Your Honor, we will make those, I filed those with the court pursuant to the court's instructions, but we would move those in as the next exhibit.
Mark it as Exhibit 12.
Now, chronicle each and every communication, and again, this is the one that we have done from the beginning, in 2022.
Yes, ma'am.
Is that correct?
Yes.
So during your pregnancy and during the early stages of your child's birth, you have sent text messages and informational things to him repeatedly, keeping him apprised of the child.
Yes, ma'am.
Have you been the one that's carried her to the doctor?
Yes.
You've been the one that's done the clothing, the grocery shopping, and things like that?
Yes, ma'am.
Sent pictures of her in her bunny costume and in her Halloween costume, and tried to keep him apprised of everything going on.
Yes, ma'am.
And in fact, these are the messages that you have put together to show that in the first year of her life, you attempted to communicate and to keep him informed, invited him to come visit,
Yes, ma'am.
opened your home to him,
Yes, ma'am.
and that is contained in this folder.
Yes, ma'am.
Mark as Exhibit 13.
And again, throughout those, there's evidence of him texting.
Yes, ma'am.
And again, you have repeatedly allowed him to come up whenever he wanted.
Yes.
And he has come up and seen your daughter a total of how many times?
7 to 8 times since her birth.
And she's how old?
2.5 years old.
Okay.
I'm sorry, how many times did you say?
7 to 8 times since her birth.
4, 7, and that's the dates that we have just said. And when we were in,
Yes.
and there's been a couple occasions when we were in court, and have you always offered to give him time when we were in court?
Yes. I have.
And has he taken them each time?
No, ma'am.
Okay, there's text messages between y'all where he says, "I'm just too wired, I'm going back home,"
Yes.
rather than spending a few hours or a few minutes with his daughter. Is that right?
Yes, ma'am.
And even this last time, did you text him early knowing we had court today, asking to make plans to see if he wanted to see her before court today?
I asked him if he wanted to see her after court last time, and then he asked me a week or two ago if he could see her last night.
Okay, and did y'all make arrangements to see last night?
Yes.
And, what'd y'all do?
We met at Shoney's at 5 o'clock, and we ate dinner and then took her to the splash pad in Hensley Park.
Okay, and was that uneventful? I mean, nothing transpired that was concerning?
No, he played with her.
Okay, so y'all went to Hensley Park? Is that
Yes.
what you said, the little splash pad there? And the
Yes.
playground up there?
Yes.
Okay. Knowing him, that you knew him early in your 20s and then you rekindled with him, has his alcohol use been a concern?
Oh, yeah.
And when it was evidence that, did you believe that he had continued to abuse alcohol?
Yes, ma'am.
And did you employ a private investigator to follow him in his home?
Yes, ma'am.
And we have that individual who's going to testify here today.
Yes, ma'am.
And did you see the home that he lives in?
Yes, ma'am.
And we've submitted pictures before. It's on a waterway.
Yes.
And is it concerning to you for him to take the child at this point in time in her life and have visitation at his home in Florida?
Yeah, I'm very concerned about it.
Okay. And again, in those text messages, and that was just the early ones, we'll get into the next ones later on, has he demanded that you indicated that he would owe you, that you would owe him child support?
Yes, ma'am.
And again, it repeatedly talked and said to you, well, if you'll just agree, I won't make you pay me.
Say that again?
Has he sent repeated messages and had repeated conversations, written conversations, talking about that if you would agree with him, he wouldn't make you pay him child support? Or has he asked and said, you're going to have to pay me child support?
He's just made comments like, you make a lot of money, you're going to be paying me child support.
Right. And you've heard his testimony when we were here before.
Yes.
And you've heard him blatantly lie to this court.
Yes.
And then he left out even another home after we went through painstakingly pulling teeth out that we did through his cross-examination. He left out he owned either another rental home in Florida.
Yes, ma'am.
And again, that's something that he did not disclose.
Yes.
Okay. How old is this man?
46.
26 years of age. Excuse me. I said 26, I apologize. How old?
46.
46
Yes, ma'am.
years of age with a military career.
Yes.
5 rental properties, plus an adjacent, another lot somewhere.
He has 5 houses. One is his primary home for a rental, and then he has 2 pieces of land.
How many boats?
3 to 5.
3 to 5 boats. How many vehicles?
3.
Okay. And he professes to have no money to come visit his child.
He says he can only afford to come once every 3 months.
What? He did.
Testified according to my notes, that he had spent over $20,000 and coming to visit at various times, and that was a burden on him. I don't know that he said he didn't have the money. I think it's a
I would
characterization.
rephrase.
I'll sustain the objection as to the form of the question, but I do acknowledge that's my recollection.
Okay. Has he stated to you that he doesn't have the money to come and visit?
Yes.
Okay. Has he complained about it?
Yes.
Okay. But during that period of time, you hired a private investigator, and he's going to testify, and were your fears relieved by what you discovered?
No, ma'am.
Were they intensified?
Yes.
You understand that there was he's charged with an assault charge in Florida. Does
Yes,
that
ma'am.
cause you significant concern?
Oh, yeah.
Okay. Does his attentiveness that he's evidenced during the time that he's just been in your home, does that concern you, given her age and given his, again, maybe jealous of the lifestyle that he's living in Florida, going out about every day? Does that concern you about your daughter?
Absolutely.
Why?
I'm worried about her safety with him.
Do you think he is attentive when he's come to visit?
No.
And again, consequences being on a boat or being in a home where there's no barrier to a
Correct.
open waterway
Yes.
concerns you.
Yes.
Drinking concern you?
Yes.
And do you think that he's been truthful with his court about his income?
No.
Not forthcoming with any?
No. Yes, ma'am.
So is there a legal basis for your objection? Overall, she's asking her a question about her interpretation of her conversations with Mr. Wiley. Obviously, in cross-examination, you can go into that, but it's not a legal basis to object to question.
I'm really not sure why he rents a car. He's drove his Honda up here once before.
Your attempts to keep him updated on your daughter, do you typically make video calls?
Yes, ma'am.
Okay, and in 2023 and 2024, do you recall how many calls that you have had do you typically schedule them, or are they spontaneous?
No, it's been various times, but most of the time in the mornings.
Okay, but they're scheduled.
Now it's around 10 a.m.
Okay.
Yes.
But were there some 48 times that you have attempted to make calls that were scheduled that he has not answered?
Yeah, there's been more than that, but yes.
Okay. Was there ever even a response on why?
No.
Okay. And again, you've kept up with a number of the text messages and the emails and the things y'all gone back and forth, and all the photographs that you've sent to him.
Yes, ma'am.
And these will be the ones through the last time we were in court in April.
Yes, ma'am.
Your Honor, we'll move these in as the next exhibit. That is the rest of the
The exhibit 14,
send her pictures, well, she's in gymnastics and doing things like that. What all
Yes,
activities
ma'am.
is your daughter involved in?
She is in gymnastics and swim lessons currently. She goes to gymnastics on Tuesdays and swim on Thursdays. She's been in swim since she was 1.
And have you
she goes
kept,
every week.
have you kept him apprised of all of that?
Yes, ma'am.
Now, what are you asking? You want to be designated as a primary residential parent, and that's
Yes,
not a
ma'am.
disputed fact.
Yes, ma'am.
What type of residential schedule do you believe would be best for your child?
As in, what in particular, as far as visitation with him?
Mm-hmm.
I mean, I think that it would be best for him to come up here and visit her.
For how long a period of time?
2-3 days at a time is fine, like he's been doing, but more frequently.
You have a problem with him coming up, scheduling at least a residential time once a month for him to come up and to visit?
Yeah,
And
absolutely. he
any
can do
other
that.
times that he can communicate and you can do it?
Yes.
Okay. And do you think and again, this is, at this point in time, I know it's hard to do, but is there a period of time that you think her age would permit him to carry her to his home?
I don't know. I guess it just depends how things go.
Yeah, with a criminal case.
Yeah, I don't really feel comfortable with that, saying that I feel comfortable with that right now.
You've read what has happened and heard me cross-examine him about it, but you've heard his statement saying he's been involved with this woman who broke into his home.
Yes.
So even if his rendition of the testimony of the events is true, does that cause you concern with
Absolutely.
who he's associating with?
Yes, ma'am.
Now, do you have a problem if he comes up on holidays, sharing holidays?
No, ma'am.
Do you want his home secured?
Yes, ma'am.
Would you request at the very least, if it's not the Department of Children's Services through Florida, or at least some type of a private agency do a visit on the home to determine whether or not it is environmentally safe?
Yes.
And again, distance-wise, do you think allowing your child to be away from you for any length of time because he's living in Florida, and it's not something you can commute every other weekend for, think there needs to be a significant period of time before she's gone for any length of time?
Absolutely. At this point, she would be terrified.
Okay. She's been away from you when you would work these shifts where you would be gone. Would you always come home and be with her?
Yes, I was with her during the day. I was working at night when she was sleeping for the most part.
And you've had to incur costs for work-related daycare?
Yes,
And is that, have you had an in-home nanny, actually?
yes.
And who
she's-
is that
she's
in-home nanny?
Renee Chesmore.
And how much do you pay her?
Right now it's $13 an hour.
And how often, what is your out-of-pocket expenses on a weekly basis to?
Um,
So again, if you're working 6 to 8 days a week
mhm.
in various times, what is the
6 to 8
average?
days a week.
A month, sorry, thank you. 6 to 8 days a month. What is the average time that she has to be there?
6 to 8 shifts a month, 6 to 8 days a month.
But the hours.
Oh, most.
You're paying her $13
Yeah.
an hour, so are you paying her for 12, 8,
Um,
24?
It varies, so most of them are 6-hour shifts at Horizon Medical Center. I've been trying to pick up mostly there, but some of them are 8 and 9-hour shifts at the ER, an 11-hour shift at Centennial. So every month is a little bit different what I pay her, but it's usually, I'd say between $800 and $1,200 a month is on average what I've been having to give her
Because, again,
based on my hours.
if you're working at Horizon, you're 10 minutes from where you live to the
Yes,
hospital.
yes,
But if you're going to Centennial or to General, you have to leave at least an hour before your shift.
yes. So she
And-
gets
and-
there an hour.
And again, if it's like any other healthcare worker, you have to get there and take report from the person you're doing, and then you have to give report.
Yes,
So even though you just work maybe an 8-hour shift, you may be there 9 hours, is that correct?
Yeah.
So
So if
again, it fluctuates with how long she's going to be there. And where does she live?
I think she lives in Charlotte.
Okay.
Yeah.
So she's
Or White
local.
Bluff area, yeah.
Okay. And you just tell her on a weekly basis, I'm going to need you Tuesday, Wednesday this week, I don't need you next week, or?
I tell her month to month. I usually have my schedule a month in advance.
Okay.
Yeah.
And so that's how you do it, and you pay her cash or you pay her a check?
I've done both, but here lately, since it varies, I just pull out cash.
Okay, all righty. Tell the court, if you would, are there any other concerns that you have about Mr. Wiley's parenting and his ability to care for such a young child that have not already been addressed?
I'm concerned about, we brought up the alcohol use, the history of physical and emotional abuse. I'm concerned about his mental stability.
Explain why you're concerned about his mental stability.
He threatened suicide when I was 2 months pregnant. Told me he was going to jump off of a bridge.
Well, what precipitated that?
He was out at a bar.
Receives disability, is that
Yes,
correct?
correct.
And that he has mental issues as far as short-term memory, things such as that. You heard him
I
testify?
heard him say that, yes.
Okay. You're in the medical field,
Yes.
and can you describe, if you could, what does short-term memory issues mean?
Having trouble remembering things in the short term. So, yeah,
I turned the stove on and I forget I turned it on.
yeah.
I put the child in the bathtub and forgot I put the child in. I asked him what the nature of his disability was, and what he was qualified for, and I maybe classifying it as mental, maybe not be the appropriate word, but his testimony is that part of his disability is memory issues, particularly short-term memory issues. Post-traumatic stress disorder, I believe, was also testified to, and that's from his testimony as to his personal physical, mental, and
Short-term memory issues, as testified to by Mr. Wiley, would not require an expert witness to interpret how that could affect care for a child. And I think she's testifying about why she would be concerned about his caring for a child. Ms. Roberts testified on her behalf about examples of how that could affect, talking about a child forgetting that you just put the child in a bathtub and so forth. But that's a real-world practical interpretation of short-term memory rather than requiring any sort of expert testimony. So overrule the objection.
all right, that's all. Thank you, ma'am.
Thank you.
All right, Ms. Burdine, you may cross-examine.
Good morning.
Morning.
So when you testify that you want for this parenting plan to say that Mr. Wiley should come to Tennessee for his visits, where exactly would these visits take place? At your house?
To be determined, wherever, whether it be at my house or in a public place or a third party. Doesn't.
Are
I
you
don't have-
asking for supervised visits? Is that what you're
That's
asking
what
for?
I would prefer, yes.
Okay. Have you ever allowed Mr. Wiley to have an unsupervised visit where you're not supervising?
No, ma'am.
Okay. And so when you testified that the child fell, you were supervising.
I was in the next room cooking lunch. He was in the room with her.
Has the child ever fallen in your care when no one's there?
She's 2, so she's at risk for injuries, yes.
Okay. Was she injured
She
when
had a-
Mr. Wiley was
Yes.
at the house and she fell?
She had a bruise on her back the next day, yes.
Okay. And has she ever gotten a bruise or a scratch
Yeah.
while in your primary care?
Yes.
Okay. Does she have to go to the hospital?
No,
All right.
she's been in the
Anything
hospital.
permanent damage or anything like that from?
No.
Okay. When did you sell the house in Alabama?
Last year,
Can you give me a month and a year?
February of 2023.
So this petition was filed. Summer of 2022. So for the first 9 months after the petition was filed, were you working in Alabama?
No, I delivered her. I went on maternity leave. I had to go back and put my notice in and work 3 months.
Okay. So at the time of conception, you were working in Alabama.
Yes.
And when did you stop working in Alabama?
June, maybe July of 2022.
Okay. And then where did you start working in June, July of 2022?
Through Apogee Physicians,
Okay. And what location were you working?
Lasky at Southern Tennessee Regional Medical Center.
On the Tennessee-Alabama border?
Yes.
Okay. And did you live there?
No, I lived here.
Okay, so did you drive down there?
Correct.
And was this before or after the child was born?
After
So while you were pregnant, where were you working?
Alabama, I would drive back and forth to do my shifts.
Okay. And do you still work in Alabama?
No, ma'am.
When's the last time you worked in Alabama?
June, July of 2022.
Okay. Isn't it true that you told Mr. Wiley you admired him as a parent before you got pregnant?
I have no idea.
You observed him raising his children when they were in elementary school, right?
Yeah, off and on.
And did you see any concerns with his parenting ability then?
He was very strict on his kids, very hard on them,
Okay.
physically and emotionally. But I never witnessed any abuse, physical abuse.
So you're denying that you told him that you admired him as a parent?
No, I'm not denying that. I don't remember.
Isn't it true that y'all tried to make a baby?
No.
See, you're saying that it was an accident?
We were having risky behavior, yes. It was a possibility.
So when you witnessed him as a parent to his other 2 children when they were younger, there were no concerns? You had no concerns?
I had concerns, yes.
But you had risky sexual conduct with someone you had concerns
Yes,
as a parent,
I did.
with the risk that he may become a parent to your child.
I did. I'm not perfect.
Are you currently in a relationship with anyone?
No, ma'am.
Isn't it true that Mr. Wiley came and chopped up trees on the property at your house? Like big 8 large trees?
He insisted to come and chop up a tree on my property. I told him not to do that, but he did it anyways, yes.
Did he say why he wanted to do it?
I don't remember.
Isn't it true you have a swimming pool in your backyard?
Correct.
And if Mr. Wiley were to put a fence on the patio, would you still have a problem with your child, with yours and Mr. Wiley's child coming to Florida to visit?
Yes, I would still have a problem with her coming there even if there was a fence
Why?
because of the volatile situation, his history of physical and emotional abuse.
Volatile situation, can you be more specific,
He was just
please?
arrested for a violent charge. That concerns me with her going down there.
And that happened, what, a month
Which one is-
ago?
I'm going to ask you, pull that microphone toward you up a little bit so it's more pointed at your mouth. There you go.
And that happened a month ago, correct?
Yes, ma'am.
And before that, Mr. Wiley, to your knowledge, he'd never been arrested, had he?
No.
And so what explains June 2022? What explains the last 2 years that you've not let him see his child outside of your eyesight?
His
What-
alcohol
explain that.
use, his alcohol use, my concern for his emotional stability, his history of physical and emotional abuse.
What
that-
history?
That I have found
What
out.
history of physical abuse?
To his own daughter, I found out. He has admitted to me when I was pregnant that he hit his second ex-wife in front of his commanding officer at a Christmas party. He's put his hands on me in my 20s.
But you got into a relationship
I
again in your
did.
30s.
I'm not perfect. I did. I was
So
at a
it
very
can't be that
low
bad if you
point in
got
my life.
involved.
I was at a very low point in my life at that time. I'm not perfect, but yes, I did choose to get into a relationship with him. I thought he had changed. I thought we were older and more mature, and I didn't know. But I learned very quickly shortly after becoming pregnant, he was even worse.
He hit you while you were pregnant? Is that what you're
No,
saying?
in my 20s.
No, I'm talking about, you said he was even worse than when you two were in your 20s. Did he hit you when he was you
No.
were pregnant?
No,
Did he push you?
no.
Okay, so how was he worse?
Just his behaviors, his alcohol use.
Isn't it true that you were consuming alcohol with him before you got pregnant?
For 3 months after my husband's death, I was consuming alcohol, yes. But never before that, and never
So you
since
don't
then.
have, so you've got mental weakness that you can't handle grief without alcohol, is that what you're saying?
No.
Hold on just a second. Form of the question being, question is argumentative, sustain the objection.
So you can't handle, you're not able to handle tough problems without consuming alcohol? Is that your testimony?
No.
Okay,
That's
well then
not true.
why were you forced to drink
Wasn't
when you were
forced to
going through a
drink.
difficult time?
I chose to. I didn't have children. I was single.
Did it help you cope with your hard times?
I don't think anything helped me cope with those times, no.
So why did you drink?
I mean, why does anybody drink? I don't know.
I don't drink, so I don't know. You
I
tell
don't have an
me.
answer for that.
I'm asking you. You said, well, I drank because I was going through a hard time. So you're not able to go through a hard time without drinking? Is that your testimony?
No, that's not my testimony.
And you said, you testified that Mr. Wiley only spent 1 hour at the hospital when the baby was born?
Correct.
And isn't it true you kicked him out of the hospital?
Absolutely not.
Can I
did
finish
not.
my question, please,
Sure,
Your
go
Honor?
ahead.
You forced him out of the hospital room when he came to visit his child.
No.
Isn't that true?
No, I did not. He
You
chose to
also-
leave.
Why did you not add Mr. Wiley to the birth certificate?
He wasn't present at the hospital when they came around to do that.
Well, you testified that he was there for 2 days.
He was there for 2 days before her birth. They did the birth certificate after her birth.
And let me ask you this, in this volume of text that you've tendered as an exhibit, are we going to find where you said, hey, Clyde, come up here and see the baby that was just born? Are we going to find text like that?
He was already up there. Yes.
But you kicked him out.
I did not kick him out. He
Okay.
chose to leave. My mom asked him to step out because I was breastfeeding, and he took offense and said he had to go home.
Because it's his child, right? And let's go to that. You said, you testified that your mom was present
Yeah,
with you while the child was born.
she was there during every doctor's appointment during the whole pregnancy.
And let me, well, Mr. Wiley wasn't able to because you basically put 500 miles between you and Mr. Wiley after he broke up with you. Isn't that true?
I don't know why he wasn't able to.
Well, I mean, 500 miles is kind of a hard, long distance to travel, isn't it?
Yeah.
Yeah. And let's talk about the birth of the child and who was there. You testified that your mother was there. Why was Mr. Wiley there? You said he was there 2 days before the birth. Why didn't you invite him and have him come? Did you allow him? Did you offer that for him to watch his child be born?
No,
Why?
because it was an emotional stressor for me to have him there. She was my support system, and my doctor said that I could choose and that I needed to have whoever supported me and whoever I felt comfortable with, and that's what I felt comfortable with.
And you testified that in March, when one of the visits that Mr. Wiley, shortly after the baby was born, he came to see his baby, and he brought his 2 other children with him, and that's Ashley, who's here in the courtroom, and his adult son, Mark, correct?
Say that again, please.
You testified that shortly after Mr. Wiley's baby was born, that he came up to see the baby, his baby, and he brought Ashley and Mark, his adult son, with him. You you don't recall testifying to that?
He didn't bring them, no. I invited Ashley and Mark to come to my house to see Anna Claire, and he asked, like the day before, when he found out that they were there, could he come up too? I knew that Ashley and him had a tense relationship, so I left it up to the kids, and they both said, yes, he can come. So he came.
And that's because there wasn't a tense relationship at that time between him and Ashley, isn't that true?
No, there was very much a tense relationship.
Why is it Mr. Wiley on the birth certificate?
Because he wasn't present at the hospital.
Have you talked with your attorney about how can we, I've seen that he wants to be on the birth certificate, how can we make that happen?
We are now objection as to privilege.
Objection as to what?
Have you talked to your attorney?
Okay.
Would be privileged. Let's just end that because he didn't enroll the child on the TRICARE, if I understand it correctly, when he testified because paternity had never been established. And it had not been established until the order goes down establishing him as the father, since there was a request for DNA testing that raises the issue of paternity. So by entering an order establishing paternity, then we're going to resolve the issue about the birth certificate. A new birth certificate will be issued as of the entry of the order of paternity. So it kind of becomes a moot question. I understand that the implication being, why didn't she, do that, but
Man's name, an unwed mother, cannot birth certificate without him voluntarily signing an affidavit. That you can't just put somebody's name on a birth certificate. You have to have affidavit.
Your Honor, my point for asking these questions is our position is this woman, and we've seen how her attorneys asked her questions, your child, and the fact that she has not once let Mr. Wiley have any contact with this child outside of her hovering over him, and not, working with him and cooperating with him and signing the voluntary acknowledgement of paternity, or working to do an amendment to the birth certificate and signing that. Nothing stops them from doing that. And it's our position that she's trying to basically squeeze Mr. Wiley out of this child's life. And we fought for 2 years And we're finally here, and that's the purpose of my questions regarding the birth certificate, Your Honor.
Well, it is, I'm well aware of the law, the fact that a woman cannot put a man's name on a birth certificate of a child born out of wedlock without him signing a voluntary acknowledgement of paternity. That is the law, as Mr. Roberts points out. It has been the law for a long, long time. So the question about why didn't she put his name on that, she can't do that unless he voluntarily consents. So it's a two-way street. And so for that reason, it is clear that she has concerns about the child being alone with Mr. Wiley, and he has his reasons why he thinks she's trying to exclude him from the child's life. All of that, I acknowledge that both sides have their position. But as the question that you ask, the objection is sustained because I think that it is not possible for her to simply add his name to the birth certificate without some cooperation, and where paternity was questioned by the request for a blood test or a DNA test, then that raises that issue, and we won't do it until such time as the paternity order gets entered. So we'll deal with that down the road, but I sustain the objection as to the form of the question because it was not possible for her to simply add him to the birth certificate. And she has answered that the reason his name was not on the birth certificate was he was not there that day to sign an acknowledgement, as I take it, that the law requires to add him to the birth certificate. So I'm dealt with that issue. Let's move on, please.
Okay. And you've complained about the child not being on TRICARE, but it's not possible for that. And Mr. Wiley's been trying to work with you on that, and you won't
I haven't
cooperate with him on that.
complained
Is that
about-
correct?
And I'm gonna address, not, and yet not one, I know this is hard to do. I'm gonna use it. Sign the application, all he has to do is print it out and sign it. Not one time has she ever requested. It's inappropriate to wait this way.
Well, that's done at the hospital, Your Honor.
She's not acknowledging that she's a mother.
Well, they both have to sign the voluntary acknowledgement of paternity, Your Honor. And that has to be done at the hospital. And Mr. Wiley was kicked out of the hospital.
According to
Basically.
you, he was kicked out. She denies that he was kicked out. Both of you are testifying on behalf of your clients. You are not asking proper questions. And the objection that Ms. Roberts points out is the fact that there is a method by which this all could have been resolved while this case was pending. It was filed in June of 2022. We are now in June of 2024. So for the 2 years of this child's life, they've been in litigation over the issue of, number one, paternity, and number two, the parenting plan that's going to be adopted. So I would simply say, all of these things are academic to the question that I have to resolve. I understand she could have requested that he sign an acknowledgement, and then he could have said, no, I'm not, until we get the DNA test. I don't know. It doesn't really affect what I'm going to do. That doesn't, I think it goes to both of their situations, but it doesn't help me in resolving the issues that I have to resolve. So I'm sustaining the objection, the question that you've been asking about this. Ms. Roberts asked her questions, and so I've allowed you to ask her questions about the fact that he never enrolled the child in TRICARE.
But there's a reason, Your Honor, and that was what my point is in asking these questions. Because the inference that Ms. Roberts was trying to make through that line of questioning is that Mr. Wiley's a deadbeat dad.
I am used to Ms. Roberts' inferences that some people would say she inferences.
Yeah.
I am simply saying that I am not acknowledging that she is inferring anything one way or the other. The record will reflect what the witness says. I'm simply, the question that she asked was, has he done anything to enroll the child? You can ask the question, has she done anything to accomplish enrolling the child in TRICARE? And then we'll be even.
Thank you. Thank you, Your Honor. Have you done anything to work with Mr. Wiley in enrolling the child in TRICARE?
No. Her doctor doesn't even accept TRICARE. So I would still have to keep my private insurance. I've already checked into that.
In the volumes of text messages that you tendered as an exhibit, will we find text messages from Mr. Wiley to you about trying to get her on TRICARE?
Probably, yes.
Okay. And Mr. Wiley also, when there was a tornado that passed through here, he texted and asked, "Are you and Anna Claire okay?" Do you recall that text message?
Yes, at nighttime, yes.
You never responded, did you?
It was at nighttime. It was like 10 o'clock at night. I'm sure we were in bed, and she goes to bed at 8 o'clock.
But he was talking to you. He wanted to make sure that his child was okay.
And I go to bed with her, so we were probably asleep at the time.
So you slept through the tornado?
Probably.
Okay.
I don't remember a tornado
We got her
coming
again,
through
I'm
my
assuming
house.
facts not in evidence. Dixon, where she was, she didn't have a tornado.
Sustained.
Now, you've complained through your testimony that Mr. Wiley, you've offered for Mr. Wiley to come and see the child when he's in Tennessee for court. We've been up here 3 or 4 times.
Correct.
Correct.
Yes, ma'am.
And the last time we were in court, he did try to see her, but you were busy getting ice cream and going shopping. Isn't that true?
The last time we were in court,
Yes. You remember that?
yeah, we talked about
That's
that
okay.
last
We
time.
talked about that last time.
I did offer for him to come and visit her after court last time, and he said he was too wired and he was driving home.
And you also have testified that any bills that you've incurred for Anna Claire, you haven't sent them to Mr. Wiley, have
No,
you?
I haven't asked him for anything.
Okay. All right. When you would go to see Mr. Wiley, when you lived in Alabama, when you lived in Coleman, it was a 4-hour drive, right?
Probably, yeah.
And you would show up extremely late when you tell him you were coming to see him, wouldn't you?
But he would complain that I would be late everywhere I went, yes. Sometimes I would be late. It just depends. Did I stop on the way? Did I go home after work to take a nap before I came? If I did that, he would be angry and say, well, you said you were going to try to be here this time, but now you're late again. Yes, he would.
And you were 2
angry about
hours
that.
late to your own wedding, weren't you?
Was it
Yeah.
2 hours late to my
Objection
own
is
wedding?
relevance.
Well, Your Honor, I'm going as to her punctuality and concerns that we may have as to her being, prioritizing herself over others when it comes to visitation and scheduling. We want to bring that to the court's attention, that we need to make sure any parenting time exchanges the parties need to understand the importance of punctuality, especially with the distance between the two.
So, and you've asked her about she was being 2 hours late to her own wedding?
Yes, Your Honor.
When was this wedding?
It's just showing a history of her inability to show up on
That's not the
time.
question I asked. I said, when was the wedding?
I'm not sure when the wedding was, Your Honor.
Doesn't sustain the objection as
okay.
relevance.
Are you aware of the things that Ashley posted about her dad on the internet?
Yes.
Okay, what are some of the things that she said?
I just remember her putting a long post about about his abuse and how he made her feel growing up.
And have you seen other horrible posts that she's put on the internet that don't pertain to her dad?
Just that one.
Did you see where she said that babies are parasites and should be killed?
No, I didn't.
And you heard her testify that she's got some mental.
Your Honor, I'm going to object as to assuming facts not in evidence. And hearsay.
Well, obviously, you're asking her about a post by Ashley that is unrelated to her father. So therefore, I will sustain the objection as to facts not in evidence, as well as to the fact that it would be hearsay if it was in evidence.
And you've testified as to Mr. Wiley's mental capacity, correct?
Yes.
And you heard Miss Ashley Wiley talk about how she had some mental problems
Correct.
and that she's got borderline personality disorder. Are you familiar with, the common knowledge as to people who have borderline personality disorder?
I'm a nurse practitioner. I'm not a mental health professional.
And that they make accusations that aren't true and
Objection,
all of
assuming
that?
facts not in evidence, calling for a medical conclusion. Mental health.
Well, when I overruled the objection that Ms. Burdine had to her talking about the short-term memory, that was because something like that did not require expert testimony. Now we're talking about borderline personality disorder. I think she would have to be qualified as an expert in the field of psychology or psychiatry to be able to competently testify about the effects of a third party, meaning Ashley rather than either one of these parties, and how borderline personality disorder might affect them. So I sustain the objection.
And are you also familiar with Ashley Wiley's drug and alcohol abuse?
No, I know she had a history of alcohol abuse.
And when she was on the stand, did you hear her, we asked specific questions about her accusations? And all she could really say is that her dad made her write essays and made her change her clothes and made her kneel in a corner because she broke a $800 glass door during one of her tantrums.
I also heard her say he picked her up and slammed her head into the wall.
And
And
did you,
she's told me other things besides what she pointed out that is concerning.
she
that
also
he did to his
testified
kid.
that she was old enough to make decisions as to what she could wear, but she couldn't seek help for that,
I heard her testimony.
if that really did happen. Why do you think you have more rights to the child than Mr. Wiley?
As far as where she lives,
Just in general, as this child's got two parents, why do you think your rights are superior to his?
Objection, Your Honor, assuming facts not in evidence. There's not been testimony to that fact.
Overruled, I think the question that she's asking goes to their position that she's trying to control the child more than she's entitled to, but I'll allow the question. If in fact she does feel that way.
so can you
Do you
repeat the
feel,
question?
do you feel like you have the right to control Mr. Wiley's contact and access to the
No.
child?
Right now, she's in my custody from my understanding, but I do understand that he has rights. My whole issue is keeping her safe and her best interest and her happiness. That's my only concern.
You are aware Mr. Wiley's never been convicted of one crime in his life?
Yes.
Okay. And so, when you say you have a nanny, is that right?
Yes, she's a family friend.
A family friend. And you think, so when did you first enlist this family friend to care for Anna Claire while you're working?
When she was 3 months old.
And did you ever offer Mr. Wiley to take care of Anna Claire?
No.
So you think it's better for Anna Claire to be left with a stranger that's not related to her than to have time spent with her father? Is that true?
Given my concerns of his alcohol use and his emotional and physical abuse and my concerns for his emotional instability, I didn't feel like that was best for her at the time.
Mr. Wiley has no criminal convictions whatsoever
Ask
that are
and answer.
alcohol related. Isn't
Objection,
that
asked and
true?
answered.
Hold on just a second.
He
Question
has-
is asked and answered, objection is asked and answered. I believe it has been asked that she's not aware of him having any prior criminal convictions.
Or any convictions at all?
Sustained.
So how often do you travel to Florida for vacation?
I probably went once a year. Or not Florida, I go to Alabama to Gulf Shores or Orange Beach.
Okay, how far is that from Mr. Wiley's residence?
Like 3 hours,
Okay.
4 hours.
And the times that you've gone down there, have you let Mr. Wiley know?
No,
Why?
because I was on family vacation. The time that he had an issue with me being in Florida, my mother had just found out she was diagnosed with stage 4 lung cancer and she wanted to go to the beach one last time. The focus of that visit was to be with my mother during difficult times. It was not for the purpose of visiting Claude.
How long were you down there?
Maybe 5 days, 4 days.
And
5
you
days.
couldn't even pick up the phone and say, hey, Mr. Wiley, we're right down the road from you. You want to have a breakfast with Anna Claire or see your daughter? No?
Actually, I continued to do video calls with, attempt to do video calls while I was down there. The first 2 to 3 days that I was there, he didn't even answer the daily video calls. He didn't know I was there until the 4th and 5th day.
Well, you
when he
didn't tell him
answered.
you were there, did you?
No.
So how was he supposed to know you're there?
The purpose
You didn't
wasn't
tell
to
him.
visit him. The purpose was to spend time with my mother who was ill.
Would you agree that video calls are not as significant as in person, seeing your child in person?
Yeah.
So you kept that from him, that the child was that close to him?
Yeah, I didn't see the point that the purpose of the trip was to be with my sick mother.
You don't see the point in your child having a father, isn't that true?
No, I do. That's not true.
I have nothing further, Your Honor.
You tried to call him 3 days, you were in Orange Beach, and he failed to answer.
Correct.
Do you know where you were standing when you were making those calls? In a hotel
In
room?
the condo with my family. I think I went to the bedroom.
He doesn't answer your call, like you didn't text him.
No.
Say, hey, we're down here. So you tried to call him.
Yes, correct.
Now, the court has to use statutory factors to determine things like that. And have you performed the majority of the parenting responsibilities as it relates to your child?
Yes, ma'am.
Including getting her on health insurance?
Yes, ma'am.
How many times has Mr. Wiley reached out and said, I've signed this affidavit, can you sign it? So we can get her
Never.
on. How many times has he sent you the application to get her on TRICARE?
Never.
One of the factors that the court has to look at is factor number 4, the disposition of each party to provide food, clothing, medical care, education, and necessary care for the child. Has he done anything in those respects?
No.
You've done that all.
Yes, ma'am.
That's all, thank you.
Thank you.
Recross? Thank you, ma'am. You may step down. We'll take our mid-morning recesses, we'll be in recess for 15 minutes.
And Your Honor, if I could ask Ms. Jennifer if are there people on I had told them to come on about 10:30. They're not? Okay, I'll make that call, thank you.
Mr. McCoy, next witness.
Your Honor, could we see if Investigator Nolan is on the? Yes. That's the deputy, yes, you can log him on. That's not. Is that Williams? Yeah.
Mr. Perrigan, if you can hear the court, then I need you to unmute and turn on your camera, please.
Why want to? Okay. Yes, sir.
All right, Mr. Perrigan, you've been called as a witness. I'm going to place you under oath. If you'll raise your right hand.
Yes, sir. My name's Jacob Nolan. I'm on my office manager's computer.
Yeah, I'm sorry, this is the investigator. It's just, but the name on the screen was not.
All right. Let me push you under oath, and then we'll ask you your name, okay?
Yes, sir.
Raise your right hand and let's place you under oath. You solemnly swear affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Thank you. Now you can state your full name and you put your hand down. So,
Yes, sir. It's Jacob D. Nolan.
all right. Mr. Roberts, he is your witness.
Mr. Nolan, where are you currently located right now? You've muted. Hang on.
You have muted.
I'm in Panama City, Florida at our home office.
Okay, and what do you work, what is your vocation, sir?
I own a private investigation agency.
And is that Nolan and Nolan Associates?
Yes, ma'am, it is.
Are you licensed private investigators for the state of Florida?
Yes, ma'am, we are.
And did you have calls, how long have you been a licensed private investigator?
We opened the agency in 2018.
Okay. And did you have cause to be retained by my client, Mrs. Jennifer Winters?
Yes, ma'am, I did.
And do you know how long, when did she seek your employment?
We were first retained by her on June 8th, 2022.
And could you tell me the nature of what you understand, what you were employed for?
Yes, ma'am. The first time we were retained twice. On the first retainer, we were looking into the lifestyle, behavior pattern, and drinking pattern of Clyde Wiley.
And at the time, my client retained you and advised you that this was dealing with a child custody issue here in Tennessee. Is that correct?
Yes, ma'am.
Okay. And can you tell me what steps you took and did you surveil him and do background checks and things such as that on him?
We did. We had a number of steps we took in the case, and surveillance was one of them.
Kind of give
Looking
me
at the
an
residence was
outline.
another.
Kind of give me an outline, if you would, of the steps that you took in this.
Oh. Sure thing. So we were retained on June 8th, 2022. Throughout the course of the next 6 months, we did surveillance, investigation off and on. On June 18th was the first time we did surveillance at the house. That's where we recorded multiple subjects at the house, drinking at the house, people coming and going, late at night activity. June 19th, we took surveillance at the house of empty beer cases being toted out to put in the trunk of a vehicle, I believe, belonging, which was Mr. Wiley's girlfriend at the time. There's not trash service at the house, so we got a lot of video of like beer cans and cases being put in the back of vehicles. On the 24th, we were doing more surveillance of the house. We watched Mr. Wiley make drinks from the trunk of a car, urinate in the front yard. On the 25th of June, again, there's activity at the house that was going on inside, so we just made note to empty cases of beer and stuff being loaded in the back of a truck that was parked in the driveway. In July, we were watching surveillance on the house. July 9th, Mr. Wiley and Renee George were out, and they came home late. And on that night, it looked like they were having a 3 a.m. argument in the driveway that we recorded video of. It looks like that argument continued to the next day because we had a little more argument in the garage on July 10th.
Okay.
I'm sorry, ma'am.
No, go ahead. Thank you.
Okay. On September 23rd is when we looked at the house following like the DCF guidelines for what a safe house is for children, what they would sign off on. Our client asked us to look into the safety of the house. So we were looking at the house was on a
Hang
canal.
on just a second, Mr. Nolan. Hang on.
Yes, ma'am.
There's an objection.
Yes, ma'am.
Your Honor, I'll lay a foundation.
All right, sustain the objection in the present form. Mr. Nolan, you cannot testify about what those DCS guidelines are. Obviously, you can testify about what he observed and how it applies. But Ms. Roberts?
Mr. Nolan, in your course of being a private investigator licensed through the state of Florida, and in being retained by my client, did you make personal observations of the property that was owned and occupied by Mr. Clyde Wiley?
Yes, ma'am. I did.
And did you, and again, in the course of your investigation, did you do research and look to determine what a court or an agency may see are obvious hazards? You made reference to the DCS guidelines.
Yes, ma'am. I checked. Yes, ma'am. I was given the guidelines for what they checked. Yes, ma'am.
Okay.
Your Honor, once again, I'm gonna object to this man, that any inference that this man is an expert as
I did-
as to what is the best interest of children when it comes to our house,
I haven't tendered him as an expert, Your Honor.
or as to his
He do. Whether it's DCS guidelines for the state of Florida are not relevant to what the state of Tennessee and what Your Honor has to do. I'm simply laying a foundation to see why he might be looking at the property and the things he would observe.
It's also saying, DCF is probably what Florida calls it, is their DCF. And so, once again, I need to know, is he looking at Tennessee guidelines, is he looking at?
It doesn't matter. This court's not allowing him to testify about what those guidelines are. Neither is he being qualified as an expert witness. He is a fact witness, and so far, the only question has been, in order to prepare for his investigation, did he consult with the, whatever it is, DCF or DCS guidelines? And then I'm not allowing him to repeat what those guidelines are. I'm not allowing him to do anything other than testify about what he has personally observed about the situation. I will then make the determination as to whether or not the evidence that he offers does or does not present an issue for this child. So
Yes.
overrule that part of your objection.
So Investigator Nolan, in fulfilling your contractual obligations with my client, did you look and visually look at the home and the surrounding area?
Yes, ma'am. I did.
And you photographed that, is that correct?
Yes, ma'am. Just the outside of the home is the only thing I have access to. Yes, ma'am.
And in that, where is the home located next? Is there a water source near the home?
Yes, ma'am. It's located on a canalway.
On a canal?
Yes, ma'am.
And were you able to determine the distance between the home and the canal? An approximate distance between it?
From the back door, I would say 50 feet.
Okay. And was there any structure, any impediment, fencing, blocking, anything from the back door or anywhere around the home to the canal?
No, ma'am. There was no barrier of any kind.
Okay. Were there other things around the home? How was the maintenance around and keeping the yard up, vehicles, things such as that? What did you observe?
We noted when we looked at the house that the fencing was down. There is a privacy fence in the front of the house that was broken, most likely from the hurricane. As far as the upkeep of the home, it looked like an average guy's home. I mean, there was cars and boats in the yard. The grass at the time we were looking at it was not overgrown or anything of that nature.
But did it appear that there had been a fencing to keep that would have to the canalway, or just the privacy fence in the front?
It was just the privacy. The only fencing the house has is the privacy in the front, blocking somebody that would be walking down the roadway to go to the backyard. That was what was broken. There was no fence in the backyard preventing anything to go to the canal, in between the house and the canal.
And your synopsis of your surveillance, was there anybody else living with or maintaining a residence at the home with Mr. Wiley?
The only person we've put there long term was his girlfriend, but she also had her own home, but she did stay over there multiple nights a week.
And you have later found out that that is an individual who has alleged or is the victim of an alleged assault.
Yes, ma'am, I'm aware.
Please sustain as to the leading.
Mr. Nolan, did you find here lately that there's been other issues between and Mr. Wiley?
Yes, ma'am. I saw there was a domestic violence arrest in their relationship that occurred.
So how long from the first time that you were hired, you said you were hired a second time, how long did you surveil him? The first time?
Are you asking for like a number of days, ma'am?
Well, just from the time, you were hired, I think you said on June, a date in June, and then when did you stop your surveillance?
Okay. Yes, ma'am. We ended up on that one. We continued when she renewed us, we continued the case. But on the first part of that case, I would say we ended most of that case around November 2022.
You said November of 2022?
Yes, ma'am.
How many occasions, or can you give me a number of occasions that you saw that Mr. Wiley frequented establishments where drinking is the predominant activity?
Where I was personally present, we have 3 or 4 occasions. If you're asking about like social media posts, I can expand on that if you'd like.
You also his social media posts, is that correct?
Ma'am?
You also, in your investigation, logged on and checked his social media posts.
Yes, ma'am. That's where we would see where he was at. If he would go out, most of the times he would post pictures where he was out drinking at.
Okay. And were there occasions that you saw him exposing himself in public? Where he would,
When we were doing surveillance at the house, he was in his front yard and he urinated.
I have an objection.
I object to this one with a question, it's considered the facts not evident and it's legal.
I'll rephrase the question, Your Honor.
Sustained. Ms. Burdine, if you'll turn that microphone on, and turn her microphone on her desk so that when she makes,
Yeah.
Testing.
there you go.
Okay.
That way, because, and the reason for that is I can hear you, but Mr. Nolan may not be able to hear you when you're lodging an objection.
Thank you, Your Honor.
How many occasions, did you ever see him out in public?
Yes, ma'am.
Did you see him consume alcohol while he was out in public?
Yes, ma'am.
Did you see him, were at any of those times, did you see him consume multiple alcoholic beverages?
Yes, ma'am.
Did you ever see him in an intoxicated state, either at home or in public?
Yes, ma'am.
Did you see him acting any other way inappropriately?
I wouldn't categorize it as inappropriate. I would say intoxicated in establishments that serve alcohol.
Okay. Can you describe his behavior when you would see that?
Yes, ma'am. I mean, he would get excited. There was no one in there that was a stranger. After a while, the last night we did surveillance on him, he would sit at multiple different tables, even with spring breakers, consuming alcohol.
Did you ever see him leave on a boat? Did you ever surveil him while he was going out into the bay or the harbor or the coastal waterway on a?
We've only conducted surveillance before he left and when he returned. We have not conducted surveillance when he's out on the boat.
When you've seen him leaving, were there alcoholic beverages being loaded onto the boat?
I can tell you when they come back, there's alcoholic cases and being returned to the house, but as far as them leaving, I can't testify to that.
But have you seen them offload?
Yes, ma'am.
Have you seen him, as he's leaving a boat, appear like he has consumed significant amounts of alcohol to the point that you believe that he was under the influence?
Most of the time when he returns on the boat, we have just followed social media where they're posting that they're at a different bar or restaurant. Sometimes those locations aren't close to where we're at. They will travel sometimes to go diving outside of Bay County.
Did you ever see whether or not he was a for-hire boat captain or carry people out? Was that part of any surveillance that you did?
I've never seen him advertise or try to recruit business as far as going out diving and fishing.
Did you determine he had other properties in other areas?
Yes, ma'am. We were asked to look into what he owned in properties. Yes, ma'am.
Can you tell me what it is that he owns?
I need to pull a report on it. I think what we noted in our report was that he had homestead filed on 2 different properties. And I can get you, if you want me to pull up, I can get you a list of what we found as far as property.
Your Honor, I object to the formula, to the response as hearsay.
I would say that he is, it's my understanding that he has pulled the public record regarding ownership of property.
Just ownership property.
Overrule the objection.
Well, Your Honor, I'd like to state, there's no foundation laid as to what, there's all kinds of information you can find when you Google, is it an official government document? What is it? It's an improper foundation and it's not reliable evidence. We haven't seen any documents. We don't know where they're coming from, Your Honor.
Yeah, Your Honor, again, my point, and I plan on calling, I'm not going to belabor this point, I'm going to call him back. We went through this painstakingly about him disclosing property. He left another one out. My purpose was going to ask Investigator Nolan whether or not he pulled records for 2307 13th Street West in Panama City, which is a home that Mr. Wiley, when he was on there, never disclosed in the last scenario. So my point,
I'm sorry.
my point in getting this was I was just going to, we've already been through painstakingly what he owns. There was just one left out. And my purpose was going to ask Mr. Nolan, did he find public records that Mr. Wiley owned a property on 13th Street?
Your Honor, my objection was as to who, homestead exemptions. I believe the witness testified that Mr. Wiley claimed 2 homestead exemptions, and that was what my objection was to. I don't know what he's talking about, what document he's looking at, and that was what I was objecting to, is to hearsay. We have submitted updated financial information as this honorable court requested my client to do, and we're not disputing that he owns multiple properties, Your Honor.
Well, if they stipulate that he owns,
There's any tax fraud that maybe, I don't know what this man's trying to lead this court to believing about my client, but it's hearsay into what he's claiming as exemptions on his taxes.
no, that's not what, in the state, he can explain tax exemption. Property exempt in the state of Florida is a sign of ownership. That's what he's pulling. But again, if they're going to stipulate that he owns 2307 13th Street West in Panama City, that property was not disclosed on his last. If Ms. Burdine, he stipulates that he owns that property.
I put 7.
We stipulate, Your Honor, we'll stipulate.
All right.
Those stipulated so that it resolves the issue.
Okay. Along with the other properties that we had already put into evidence. Investigator Nolan, in your surveillance, the number of days that you surveilled, how often on those days did you find that Mr. Wiley was drinking alcoholic beverages?
On the days we were able to locate him, he was usually consuming alcoholic beverages. There are days that he was not at the house. We couldn't locate him anywhere. We count those as days of surveillance because we set up, but we didn't see anything on those days.
But each time that you were able to make contact with him and put eyes on him, through your investigative services, he was imbibing and using alcoholic beverages.
Your Honor, I object to that question. It's leading and it's in contradiction as to what this witness has already testified to. He testified that the first time he was hired, he saw on 3 or 4 occasions Mr. Wiley consuming alcohol, and that's not, and so this is leading, and it's also not what he testified to and is asked and answered.
So we've got a number of options I can choose from for this objection, but I am going to say that it is leading. So sustain the leading objection and you may restate your question.
Were there ever any occasions when you had personal surveillance on him that Mr. Wiley was not consuming an alcoholic beverage?
Yes, ma'am. There's been times where I've seen him in the mornings where I don't believe he's had something to drink yet. Yes, ma'am.
But when you would see him through the day and in the evening?
Yes, ma'am. Almost every evening or night surveillance we did where we located him, he was consuming alcohol. Yes, ma'am.
And can you give quantitative amount of how many occasions you saw him, that you actually, through your surveillance, how many occasions did you actually make contact and see him?
I would have to go for an exact number through our reports, but I would say 15 to 20 reports are in our system for surveillance.
And that was between what time and what time?
Are you asking dates or time of day?
when you were hired?
Okay, that would be from the beginning, from when we're hired up until when we closed out, which is around May of 2023.
So from June of 2022 to May of 2023,
Yes, ma'am.
that would be it.
Yes,
Did you
ma'am.
have occasion to make contact with a deputy, Aaron Williams, also?
Yes, ma'am, I did.
And did you take a sworn statement?
Yes, ma'am,
from
I did.
Deputy Aaron Williams, and who was Aaron Williams employed by?
The Bay County Sheriff's Department.
And do you know whether or not, I asked you before we started, were you able to make contact with the deputy today?
I was not able to make contact with him today, but I forwarded the subpoenas to him a few days ago, and he did reach out to me. I have not heard from him today.
Okay, all right, thank you. Now, Ms. Burdine may have some questions for you.
Ms. Burdine?
Yes, ma'am, thank you.
Let's examine the witness.
Thank you, Your Honor.
So the last time you surveilled Mr. Wiley was in May of 2023. Is that your testimony, sir?
The last time we did surveillance would be, I believe, March 17th, 2023. We just closed out our case after that.
Okay. And all the times that you've observed him, can you count how many times you went out and observed him during the period of June 8, 2022 through May of 2023, March of 2023, I'm sorry.
You want a number of times we did surveillance?
Yes.
We have 22 reports logged in our file for a field report, and I would have to go through each one, but 90% would be surveillance.
Okay, and let me ask you, all the times that you went out and observed over these 20 plus times that y'all have gone out.
Yes, ma'am.
And surveilled Mr. Wiley, did you ever see him in the presence of children?
Not that we're with him, no, ma'am.
Okay. How much were you paid by Miss Winters to surveil Mr. Wiley?
Our billing rate for her at the time was $150 an hour, and I believe she totally, don't have the invoice in front of me, but I believe she.
Okay, that's all I have, Your Honor.
Thank you, sir.
Yes, ma'am.
Roberts?
Nothing further.
All right, thank you. You are now released, Mr. Nolan, from further testimony, and you may exit our hearing. So.
Thank you, sir.
May I ask? You understood when we left court that the judge ordered that both you and my client produce your tax records, your tax filing records for 2022 and 2023. And as we're sitting here today, you have not done that. Is that correct?
That's not correct.
I want to show you what your attorney, and I believe it's it's not made a record in this case yet. It's been filed as a late file. Your Honor, may I approach?
You may.
I received a document from Showdown law firm
Ma'am, that document is what was filed. Can I explain? Okay.
Your Honor, my
that-
client should be given an opportunity to explain his answer, Your Honor.
Ms. Roberts, I'm going to allow him to have an opportunity. The question was, you have not filed the actual tax return that was filed with the Internal Revenue Service. And his answer was no, and if he wants to explain it, I'll allow that.
Yes, sir. I cannot find that tax return. I found the file that was filed. It was not readable, so I went to my Amazon account and I re-downloaded Tax Cut. So the actual file, which is that one, was not readable by my computer. So I went on my Amazon account, which I ordered the tax program through. I downloaded the tax program. I was able to open it with the file. Now the file is readable because I had to download a previous tax return program. And the file that I filed on my tax return, the data is that data. When I re-downloaded the program, it gave a message, do not file. It was a product of me having to re-download the program that is now out of date. Those data, that information is what was filed. That's the file I have that I filed.
But there's no 1099s, there's no W-2, there's no documentation with this, is there?
I didn't know that I had to provide that. There wasn't one with the other one.
You file that with your
I thought I was supposed to submit my tax return to you guys for those years. I didn't do my W-2s and all supporting documents for any of them. I filed that, I was required to provide my tax return for each year, and that's what I did.
When we got
That's what
discovery,
I
we
understood.
asked for evidence of your income, and you didn't provide W-2s or anything then, did you?
I provided my
299.
current, I don't know what to say.
You had
I've
100
given you everything with transparency, and I welcome any questions. And I will answer to the best of my ability.
$114,672, plus you had income, you had other taxable incomes from pensions and annuities of $18,024. There would have been a 1099 or a W-2 supporting those numbers, and you did not produce those for this court, did you, sir?
Right, correct.
You have other income
Correct.
that should have been listed on Schedule 1, line 10, that you said you had an $8,000 loss. You recall that?
I don't recall much of all this. This is years ago
But
tax
there's no
returns.
you just said,
Right.
you just have taxable income, and you have rental, real estate rents, royalties, S, trust, attached, Schedule E for you have a loss of $8,652. But again, there's no supporting documentation to that,
Correct.
is there?
Correct.
And again, interestingly enough, the only property that is listed on this tax return in 2022 is 4,000 Gulf Terrace, Destin, Florida, that says you received $6,200 rent, but you had auto and travel expenses of $3,630. You had repairs of $2,959. You had depreciation of $3,333. $1,000 for a hot water heater, so you took a loss of $8,652, but there's no supporting documentation on any of that.
I did not provide it.
And you didn't list any other your rental properties that you have on there. Why not?
They were unrented.
Beg pardon?
They were not rented. Any house
So
I've,
it's your testimony under oath, under penalty of perjury, that in 2022, none of your other properties were rented. Is that your testimony, yes or no? Yes or no?
I don't know.
Why did you just say they weren't rented then?
Hold on a second. Can I answer? You're
need
making
to
me say
answer
yes
my
or
question
I am.
first.
What I provided is factually correct, and I stand behind it. You asking me on the fly questions, I don't know. Whatever is provided in that document is
And-
factually correct.
Answer the question, sir.
I don't know.
Are you testifying under oath that no other properties that you owned in 2022 were rented? You received no rental income or other than 4,000 Gulf Terrace, Destin, Florida. Is that your testimony?
Yes, if that's what that says.
I'm not asking what that says.
Well, I don't know. I don't know.
Okay. Well, I don't know.
I know that's correct. Yes, it appears to be.
Does it appear to be, or is it correct?
I'm not looking at the tax document.
You may, but let's let him look at the exhibit that's been filed. I think it's the same one that was filed June 20th, 2024, income and expense information. I will hand that to the clerk, and if you'll hand that to Mr. Wiley. That way you can question him about it and reference the pages and
If you will flip over to where it starts, the page that says 1040 U.S. Individual Tax Return 2022, and it started printing draft form, do not file.
Yes, ma'am.
Shows that you are Clyde Wiley, living at 2622 Michigan Avenue in Panama City. Is that correct?
Yes.
You have no deductions, and you come up and you say your total income from W-2s, $114,672. Is that correct?
That is correct.
Then it goes down and you talk about that you have pension and annuities of $18,024. See that on line
It does
5B?
say that.
What were your pension and annuities?
I don't recall.
What was your income from?
That appears to be from rental income.
Appears to be what?
I believe rental income. I'm not sure. It asked
So
me.
you got $114,000 in rental income on line 1A?
No, that should have been Army.
That was all your
compensation.
income from the United States military, is that
It
correct?
should be, yes.
So for 2022, how, were you in the military from January 1 until December 31?
I was in the military from that full year till October, I believe.
You retired in October of 2022.
Yes, ma'am.
So 114 was a partial year's income from the United States military.
Yes, ma'am.
Were you drawing any pensions or benefits other than at the time from January to October?
No.
So after October, did
Trying to
you
make sure I
start?
understand your question. Your questions get very convoluted sometimes. But I was active duty military, drawing that 114, I believe, to be my military paycheck for a
So had
partial
you
year.
produced your entire copy of the document that you filed, there would have been a W-2 from the United States military
Yes.
of 114,000.
Yes.
Then you retired sometime in October.
Yes, ma'am.
And at that point in time, did you start receiving pensions, a
Yes.
pension or an annuity or something? And your records indicate that on 5A, you would have received $18,024.
Okay.
But again,
That's what that is. Yeah, that's not rental income. Yeah, that's, yes, ma'am. That should be retirement income.
okay. Then you go down and it says other income. You see where it says on line 8?
Yep. I do.
And you have a
Yes, ma'am.
negative $8,652. Is that right?
That is correct.
And if you take a page over, and that's the summary, that your total tax was $24,359, and you overpaid, so you got a refund of $3,861. You see that?
No, but I hear you.
If you will look on line 33, it says what you owed, your total payments that were made to the Internal Revenue Service.
Yes, ma'am.
But then they calculated your tax and you overpaid $3,861. And on 35A, it says you got a refund of $3,861 for your tax overpayment.
Okay. Yes, ma'am.
Flip over the next page is what's called a Schedule 1. You familiar with the document?
Okay.
And if you go down, it says on that you, number 5, rental, real estate, royalties, partnerships, S corporations, trust, etc., attach a Schedule E. See that?
I don't, but
Line 5.
I'm following you. I'm on
Line
different-
5.
Yeah, it's okay. I'm following.
Okay? And it says when you would have filled out your Schedule E to show that you have a loss of $8,652. If you'll flip 2 pages over, there's a Schedule E,
Okay.
supplemental income and loss.
Yes, ma'am.
And it says, and on line 1A, it says physical address of each property, street, city, state, and zip code.
Yes, ma'am.
4,000 Gulf Terrace, Destin.
Yes, ma'am.
And it says on that, you fill this out and says that you got rental income on line 3 of $6,200.
Okay.
And it says
$8,000.
that you had to travel and you had auto expense of $3,630.
Yes, ma'am.
What was that about? Because we don't have any documentation to justify that.
I don't remember. But I kept accurate receipts when I filed my taxes.
Insurance of $556, that would have been your insurance for the home, is that right?
It says insurance.
Management fee of $930, who manages that property?
That was the property manager there at Gulf Terrace.
Okay. You had to make repairs of $2,959.
Yes, ma'am.
Then you depreciated the property at $3,333.
Yes, ma'am.
And apparently you maybe had to replace a hot water heater for $1,000 even. It's what's reflected on this. So you would have the receipt to where you paid $1,000 for a hot water heater. Is that right?
Yes, ma'am.
You have that.
I had it at the time. I probably have it still now.
You understand you have to keep 3 years' worth of your tax returns.
I probably can dig it up somewhere.
Well, do what?
I didn't even have my tax return for this thing. I had to file. But yes.
Well, you can be audited.
Right.
And
I will
so-
be ready for any audit.
You would be ready. So you have
Absolutely.
that documentation.
Yes, ma'am.
And so ultimately, my question comes up and said, you only were renting in 2022, you were only renting 4,000 Gulf Terrace. You did not have any of your other properties rented or received no other income from those properties.
That
Is
is
that correct?
correct. Yes, ma'am.
And you took no other deductions for those properties.
Correct.
Okay. Now, 2023. Flip on over a few pages and go what you've attached as your 2023. You understand the judge said file your tax returns. And this is not for filing. What you've attached is something that's not for filing. And that's what it's stamped on?
Yes, ma'am.
And you had, and it shows that you had no W-2 income, but you had pension and retirement income of $72,288. But again, a 1099 is not attached to evidence that, is it?
No, ma'am. I don't, we're doing 2023?
Yeah, this is just the one you filed by April.
Yes, ma'am. This is,
Well, I've given you the only thing that was filed by your lawyer. Ms. Roberts, if you have
You want
something.
me to show you where it is?
no, it's okay. I can follow along so far. I mean, yeah,
Okay.
2023.
2023 is at the back in the
Okay,
very
yes.
last section.
Yes, sir.
It's copied crookedly and you cannot see everything.
Okay.
Okay? But it says you have itemized deductions of $13,850. Do you know what your itemized deductions were?
I thought I did a standard deduction, but I don't not know. I don't know that I've ever done itemized deductions. So, but no, I don't know. For sure it's not standard.
But it goes, and then maybe, again,
I don't believe I've done itemized deductions.
there's something attached on from a Schedule 1. And again, something about your federal tax returns, a mini worksheet with zero. And then, if you go over, it says on line 5, rent royalty partnership, subchapter S from Schedule A, you have a loss in 2023 of $2,796.
Yes, ma'am.
And if I go over to try to find a Schedule E, there's a Schedule 1, a Schedule 2 with zero information on it, a Schedule 3 with no information on it. And then we get over to Schedule E, and you have listed one property that you've rented, 1814 Grant Avenue.
Yes, ma'am.
And yet you received in 2023, $800 is what you received there.
Per month.
No, no, sir.
Yes.
Your tax record says total rent received. $800.
And not per month.
No, sir, it's not. But then when you go down, you pay $100 in taxes, you depreciate it. Take a loss of this money minus the $800 you made, and you deducted a loss of $2,796. You filed.
Yeah, I'm not sure. I'm not, yeah, I mean, I see it.
It's untrue.
Then that is not true. It's $800 a month, and that's what it should be.
So this.
So I need to do an amended tax return for that.
Okay,
It was $800 a month.
okay, so that's wrong. Who prepared your taxes for you?
I did.
And then as I go on through this, I see nothing about any other rental properties. And again,
That's correct.
we spent ad nauseum cross-examining you earlier about your rental income from other properties. So these tax returns are not true, are they?
Well, the $800, if that's the total amount, is definitely not true, but the tax returns are true. otherwise.
But you were renting out other properties too, and you had other income from rental properties.
No.
It's your testimony again, under oath, and I caution you under penalty of aggravated perjury,
Yes, ma'am.
that you received only $800 of rental income from all of the 4 rental properties you have in 2023. Is that your testimony, sir?
I did not have 4 rental properties. My testimony is in that $800 total amount is incorrect, but that was the rental property. My rental properties were not, you keep saying I have 4 rental properties. I did not have 4 rental properties.
Well, when did you,
I have
What
I have a house
property-
full of storage.
what properties do you own, sir? You own the house in Alabama.
I have a house in Alabama.
Is it vacant?
It is vacant, absolutely.
Beg pardon?
Yes, ma'am, it is vacant.
How long's it been vacant?
I don't know, 3 years.
3 years?
when I moved out. It's been vacant.
Okay. No, that's never been rented?
No,
You have another property in Alabama?
no,
Just one property in Alabama?
well, I had two. I got land in Alabama.
Okay. Where's the land?
It's in Delville, Alabama.
And is it just open land or is there structure on it?
It's farmland.
Farmland? Does anybody harvest or do anything on it?
No,
Do you pay taxes or anything on it?
I do pay taxes on it.
Okay. But you don't take that off as a deduction on your tax return for some reason.
Yes, correct.
Alabama has a state income tax, you know that?
Yeah, I'm a resident of Florida.
Huh?
Yeah,
In 2022, you worked full-time in the state of Alabama, if I recall your testimony.
I was military in 22.
So you
and I
don't-
was
you're
a
exempt-
resident of Tennessee.
You're a resident of Tennessee in 2022?
If I was in the military, yes, ma'am.
So you had a primary residence in Tennessee?
And then I retired and I moved to Florida.
Okay. So you didn't have to file, are you exempt from filing Alabama to state tax if you're in the military? If you earn income in the state of Alabama?
Correct.
You have the rental property on, what is the Riverview property?
Riverwood is
Riverwood.
Alabama.
That's what?
It's an Alabama house.
Okay. You have Grant,
Yeah, I call it the shack if we.
but that's rental property, because you said you got $800 a month in 2023 for it.
Correct.
That you didn't disclose as income.
Apparently there's a mistake on the tax return that you just identified.
Okay.
Thank you. I will file amended tax return.
But you put on your income and expense statement, did you go up on the rent?
I did.
Because now it's $1,200.
Correct.
And that's paid for and there's no debt owed on that, isn't that?
I bought it for $28,000.
I didn't ask how much you bought it for. I said, is there a debt on it?
No, there's no debt.
No mortgage.
Correct. There's
in
no
20
mortgage on any properties. Just to
So in
keep-
2023, you were getting 800 and now you're getting 1,200.
Correct.
How long you been getting 1,200?
Since January.
This January. You got a vacant lot on Callaway?
Yes.
That's in Florida.
Yes, ma'am.
You have rental property on Gulf Terrace
Gulf Terrace is rented out.
and and you said on your income and expense statement, you're making $1,850 a month rent on it.
That's correct.
And there's
Where
no
is that
debt on it.
located?
It's the
pardon?
Destin.
Where is that located?
Panama City.
No, sir, it's Destin.
Destin, excuse me, Destin,
Pull
Florida.
that microphone towards you, and you won't have to keep
Yes, sir.
moving towards
Yes, sir.
it.
It's Destin.
Okay. And then you've got the property on 13th that has
Yes.
been rental property.
It is not rented out now.
Has it been rental property?
Briefly when I purchased it
When was that?
after Hurricane Michael 6 years ago.
6 years ago. So you
Yeah.
had rental income from it. How long has it been vacant?
Years. It's currently listed on Zillow, though I'm trying to rent it.
You're trying to rent it?
Yeah, it's
And then
vacant.
you have rural land, 40 acres. Where's that?
That's in Delville, Alabama,
And then where do you have, and then Michigan is what's your primary residence?
primary residence.
Okay. Was Grant rented in 2023?
I'm not sure.
Was Gulf Terrace rented in 2023?
I'm not sure. It's all in front of us. We can look at it and figure it out.
Well, but we've established this is not true.
It is true, except for the $800. Everything else is factually correct to the best of my knowledge, ma'am.
Well, but how can you know it's factually correct if you can't sit here and tell me whether or not Terrace was rented in 2023? Because you didn't list
It
any
rented
income in.
It rented this year,
Gulf Terrace rented in 2023, 2024.
Yes.
It was not rented, it was vacant in 2023, is your
Yes, for
testimony.
repairs, yes. It rented a partial year, I believe, in '22, and I needed to repair it. Most houses I have are not live-in ready. I've got to work on it. I've got more repairs to do than I have money to do. As money comes in, like any shrewd business person, I put the money back into the houses. In a year from now, I plan to sell these houses. They're a headache and I don't need the money. I don't make money on them. The house prices are going up. That's why I've held on to them. It's capped out. I need to get rid of these houses. They're a pain in the neck.
You have done something, what does personal finances with /LLC?
Okay, so between last court case and last court hearing a couple weeks ago, and now I've started an LLC. And in the name of transparency, Your Honor, I've provided income with no LLC, which was the current case 3 weeks ago, and now I've started an LLC, so I've left two of those. I have an LLC, and moving forward, we'll have an LLC to separate. It's something I needed to do. Coming here, made me realize I need to get this stuff in an LLC.
Okay, where's your paycheck stubs?
I just started an LLC.
No. Okay. I've moved on. You wanted to say something about an LLC. Where are your paycheck stubs? The judge wanted you to bring your current paycheck stubs, your income information, and I can't find it in this that you did.
I have provided that previously. Me and Ms. Winters had to provide our paycheck stubs. That was not, to my knowledge, brought up in court. We had to provide our tax records for the last 2 years.
In current income.
Correct.
And you haven't provided anything that shows.
Well, not
your
in current, I'm
military
sorry.
retirement.
I'm on autopilot. No, and that was not said. I have already provided current income. I've provided documents of it. I mean, look, what I've provided is actually correct. It's
Well,
a
I was mistaken, and you made a good point. And you
But I professed it, and it's
And it's your
declared.
testimony that you make an even $6,200 for military.
That is 100% correct.
Okay. Again, you haven't produced that in this.
I did that previously.
Okay. And you put in there that you have rental income of $1,200 now, as we're sitting here today, $1,200 for Grant and $1,850 for
That is
Gulf
correct.
Terrace. And you've not produced anything, any documents, books, records, anything to show any expenses at either one of those.
Any expenses?
So again, your
On my income sheet,
Your income is $6,200 from military, $4,313 from the VA,
Yes.
$1,850 from Gulf Terrace, and $1,200 from Grant.
Correct.
Is that your testimony here, that that's all the source of income you've got?
I think it's pretty substantial, and yes, it is. And it's 100% knowing, yes, it is, absolutely. It is my current income.
Nothing.
Redirect. I'm sorry, Miss, do you have questions for your client?
So, Mr. Wiley, let me ask you, the efforts that you've made to see your child over the past 2 years, can you testify to that?
Well, Your Honor, again, I'm going to object, as this is outside the realm of, I've called him as as a witness, and again, so her cross-examination is limited to what mine, and it was only on income.
Well,
Now-
it was rehabilitating my client as to some of the testimony that was made against him, Your Honor.
They've rested their case.
Well, Mr. Wiley was called as a, as a witness, an adverse witness, but that does not limit, even though he was called as a part of your case, Ms. Roberts, so it does not limit his attorney from being able to ask him questions. And if she chooses to try to rehabilitate him, that's her choice, but we'll allow her to ask those questions over.
What's my question?
Something about visiting.
Yeah, so the efforts that you've made to see your child, you've heard some statements that were made that you were offered to see her, and you didn't when you would come to Tennessee. Can you explain why you didn't see her when you come to Tennessee for court?
I would like, as a point of clarification, to explain the last trip that I came to visit, because as it talks, it wasn't the issue at all of my issue of her being out in Nashville and me saying, can I see her? I'm perfectly okay with that. I mean, it shows a prioritization, as you point out, that the father's seeing the child as lower priority than his place. You pointed that out. That wasn't my issue. I'm used to that kind of stuff. My issue was when she got home and FaceTimed me, and it was still daylight out, and I'm 5 minutes up the road, and I said, can I see Anna Claire in person? And she said, we're about to go to bed. When I'm 5 minutes down the road FaceTiming my child, and it said, no, we're not going to let you do that, and you're 5 minutes away, that was the issue with not being able to see her. I would like to clarify, since you asked on this subject while it's on my mind, After court is not the time, and I hope in a common sense measure, I don't want to be around Jenny after these heated, contested court cases that are fruitless. It's not the time for me to visit my child. I desperately want to spend time with my child. That's why I'm petitioning, that's why I'm here. But after court, being able to see her at her house, that's not the time to see her. It's just not right? The emotions are high, tension's high. I'm wide awake, I'll go home. It's not that I don't want to see my child. I absolutely want to see my child. But after court I want to unwind and relax and be away from the mother, really, because I'm forced to see my child in the mother's presence, in her house. If anyone's ever had an ex, do you want to go in your ex's house? That's her domain, that's her castle. I feel micromanaged. I feel watched over.
Did you know you were being photographed by her?
No, I would never do that. The things that are being done to me, I could have hired a private investigator. I would never do that. I want the child to have a mother. I don't want to, unless there's abuse going on. It's not my agenda to do everything I can to keep the child from the mother. And do I know things? Yes. Look, we know her husband. We know the tragedy that happened. Were there issues in that house that I'm aware of? Yes. Am I going to bring it up? No. I'm better than that. And I would expect
Your
the
Honor,
same.
I'm going to object as to non-responsive. This is not a point in time for this man to sit there and to spout his diatribe about the things. It needs to be a question and answer format rather than him just making some in-bank statements.
Ms. Baines,
Non-responsive.
it is non-responsive. A question and answer format is required. It cannot be that you just want to open the door to let him say whatever comes to mind. So
Yes, Your
this is
Honor.
not a stream of consciousness approach.
Okay. Now, you heard your oldest daughter testify that you grabbed her by the neck. Can you address that? Did you do that?
No.
Why would she say that you did that?
I believe why she would said with that issue, we're jumping right into the middle of a child breaking a door. I'm answering the question. Why did she say I did it? Because when she was kneeling on her knees, after being there for an amount of time, and this is a long time ago, but she looked away. She was looking around. That was not the purpose of her punishment of kneeling and put your nose in the corner. Think about what you did. You just busted out a window. I want to make sure that you think about what you've done. That's the punishment of a $500 window. She looked away. I do remember taking her head, putting it back in the corner and said, you need to put your nose to the corner. Not physically, not bashing a face in.
Did you yank it?
No,
Twist it?
absolutely not. No, I moved it back. And I can imagine how traumatic that is when you're looking around and someone moves your head. But I said, no, your head goes into the corner. She was furious.
Was she living primarily with you at the time that this happened?
Yeah, she was living with me.
Okay, so for how much longer did she live with you?
Another year, roughly. I mean, this is a long time ago. This is 9 years ago. I believe, 9 years.
And you heard the private investigator, he said that he saw you out drinking and having a good time. Let me ask you, when's the last time you've had a drink?
The night of the incident with Renee, I haven't drank since.
Why not?
Well, I told you last court case that sometimes events in your life are happen and you those are key drivers for things. It's and being addicted or whatever's being accused of alcohol. It was easy. It was as easy as choosing pizza over chicken. Do I miss that? No. It's easy.
Are you still going to the restaurants and seeing friends and having a good
Yes,
time?
I am. I
What
did.
are you drinking when you do go out?
I drank a club soda and lemon when I went to one place, and then kombucha when I went on Sunday. So I like to drink a beverage, but kombucha, it's a thing they sell there. So everyone, if people are drinking, listening to music venues, have a drink. But it's water, a lot of water.
Okay. And what, what kind of parenting time do you want with Anna Claire? I mean, you haven't seen her. I'm not saying that it's your fault that you haven't seen her, but it's been 2 years since we filed. She was a little bitty thing when we filed, and she's going to be 3 soon. But you haven't seen her that frequently. What do you suggest as her father and are you asking honorably, this honorable court respectfully, what kind of parenting time?
Well, like any normal co-parenting schedule that a normal father and mother would have with their children, and I think I answered this last time that ideally, 50% of the time. I don't want to infringe on the mother's parenting rights. I respect that. And I'm not going to be selfish and want 51%. I would like as much as I can co-parenting as possible. And
What about when she
feasible.
starts kindergarten? 50% of the
Right.
time is
I
not
know.
going to work.
Yes, ma'am.
When you're 500 miles apart.
And I said status quo last time, not meaning my current status quo, which is not part of it in anything. A normal parenting, co-parenting schedule where you have a primary custodian and then you have a secondary custodian. So summers and if I'm not awarded primary custodian, summers and, holidays and a normal schedule. I'm not the first one to go and be at a distance to do co-parenting. And I'm not advocating that the child not be a part of her mother's life. I believe her mother loves the child. I love the child too. And I believe her mom knows that, despite all this stuff.
And you've heard the private investigator testify, and there were some pictures that showed the backyard of your home. It's 50 miles from a canal. How deep is that canal?
50 feet approximately.
50, I'm sorry, 50
That's okay.
feet, sorry.
I think everybody knew. It's 5 feet roughly.
5 feet deep.
Yeah.
So what protective measures do you have in place to make sure that your daughter, if she comes to stay with you and spends time with you and lives there, won't wander into the canal and drown?
Ma'am, it's easy. I haven't built houses, but I've remodeled houses. It's very easy to put a sheet of plywood up, put screws into the columns. I mean, it's literally, once you have the material, screws and plywood, with the impact driver, it is a 5-minute thing to put a corral them where there's a outdoor area.
Are you talking about corral around what?
Corral around the overhang on the back porch. We're worried about the back porch and the water. You just put up plywood, screw it into the pilings, the whatever you call those things.
How big is this back porch
Yeah,
you're talking about?
it's about out deep. It's probably 6 feet deep, and then you have pilings every 6 feet. So a plywood would perfectly fit it. You just
What if
make
she
a little corral
wandered-
there.
I'm sorry, I didn't mean to interrupt
Yes,
you,
ma'am.
but what if
That's
she
okay.
wanders out the front door? How are you going to keep her from falling into the canal?
Canals in the backyard. I mean, you.
I know, because she could walk around back there. Little kids, they can take off
Yeah,
running.
right.
And what if she did that and she fell into that canal? If she left the front door, what would you do?
Well, if required, I think I mean, you could say anything, right?
Do you have alarms on your door that go off if a child exits
No,
the house?
I don't.
Can you put
I can
alarms
do
up
whatever,
or anything like that? Like-
whatever is needed, I would gladly do whatever is needed to suffice concerns of her safety for the house. That's easy. We've established I have income. I would do whatever it takes. Whatever deems that. I feel like that's a low risk. I'm going on a tangent. I won't, but I've raised children before safely, and they're alive today without issue.
Okay, and let me ask you this. The last time we were here, you had just recently been charged with some pretty serious offenses. What's going on with that?
Well, it's no change really. I mean, I
Have you been indicted? Has there
No.
been has there been anything, has there been a
I've
preliminary
consulted.
hearing?
No, it's all done through my attorney, and I'm going to paraphrase, probably shouldn't, but he says, don't worry about it. You were in your house, she entered illegally, you're allowed to have a gun.
And
Objection, hearsay.
Sustained.
let me ask you this. Did you have to pay post bond to get out of jail?
I did,
And did you have bond conditions of no contact with the alleged victim?
Correct.
Renee George?
yes,
And have you had any contact with her?
no. Well,
So you
yes,
haven't-
she's
you haven't reached out to her?
I've not reached out, she's reached out. She sent a song, basically, I messed up, paraphrasing lyrics, and I'll never see you again, and I hope to see you again, basically.
When did you receive that from her?
About a week and a half ago.
Okay. Do you expect to ever get involved with Miss Renee George again in the
No.
future? You're saying that relationship's over?
Yes, I mean, there's a no contact order, so obviously,
And who's living with you in the house now since the last time we were in court?
nobody.
Okay.
She wasn't living with me then.
Or do you have people staying over
No.
that are not related to you?
In the summertime, I do have people that come and maybe can fish, but obviously if I have a child, I'm not going offshore fishing.
Are you going to have people in the house when
No,
you have a child?
absolutely not. But having not having people, I have people wanting to go fishing, friends, they want to go fishing almost every weekend. And yes, they drink beer. It was summertime when viewed.
And I've just got a couple more questions for you. So when your two oldest were children, little children, and I know you were fighting in wars and gone a lot, but when you were home caring for them, did you consume alcohol back then?
No, I did not. When they were
Okay.
young, I did not.
Did you consume alcohol when they weren't in your physical custody?
I don't recall.
Okay.
I mean, they were in my physical custody when they were young.
Yeah.
When they were older, they went to live with their mother. When they were in fifth and sixth grade, roughly, they went to live with their mother for 3 years. Did I consume alcohol in Korea? Yeah, that's about the time I started drinking. They came back. Have they ever seen me drink? Yeah, but I did not do it when they were children, not with them.
Okay. I think that's all the questions I have, Your Honor.
Ms. Roberts, anything further?
No, Your Honor.
Thank you, sir. You may step down. We're at the lunch hour. Are you going to have your other witness?
Your Honor, the officer just texted me. He had been on a medical call, said he would be free in 10 minutes. I will call him when we take the lunch break and ask him if he can log on whatever time you decide to come back
We
on.
can start back at 1:15.
1:15, I will check and see, and if not, we will conclude if he's not available, we'll conclude our proof.
All right. Do you have any rebuttal proof that you intend to call?
No, Your Honor.
So when we finish with this last witness, then we expect that to be the end.
And Your Honor, if I could, I know you're taking the lunch hour, but I would move respectfully just to dismiss at this point in time, since they have closed their proof, and she says she's not other. There's been no testimony on his part about the name change. And so statutorily, he has to prove the 5 factors as far as requesting a name change, and it wasn't even mentioned on his direct proof. So I would just request that the court deny that request at this point in time, and that be taken off the table.
Well, no, Your Honor, we've brought up the birth certificate on multiple occasions, and Mr. Wiley testified last time on multiple occasions that he wanted her to have his last name. He did testify to that.
Well, I apologize, we'll just say that I just thought that would be one thing that we could
Well,
do.
I don't think there's anything in this case that can be agreed to, or else we wouldn't be having this hearing. So we will stand in recess to 1:15. All right, good afternoon.
Hello.
If you would let me place you under oath, if you'll raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you. Ms. Roberts, you may ask.
Would you state your name for me, please, sir?
Aaron Williams.
And Officer Williams, you are currently a deputy employed by the Bay County Sheriff's Office, is that correct?
No, ma'am. I work for EMS service now. Yes, ma'am.
Previously, you were employed as a deputy for the Bay County Sheriff's Department, is that correct?
Yes, ma'am, for 5 years.
For 5 years, and good, that was going to ask, how long had you done that? When did you leave employment with the Sheriff's Department?
Back in January.
When you were employed back in 2023, did you reach out and were you contacted by a investigator, Nolan, in reference to an individual by the name of Clyde Wiley?
Yes.
Okay, and at that point in time, again, just kind of getting some foundational stuff, were you on a special detail with the Sheriff's Department where you would work at a local establishment known as Patches Pub?
Yes, ma'am.
And when you were working at Patches Pub, did you have any occasion to witness and to view and see Mr. Clyde Wiley?
Yes, ma'am.
Can you tell me about your interaction and your observations about him?
Yes. I've seen him a few times there. That's one of the main details. I used to work when I was employed there. Every time he's there, he's at a table full of people. He's drinking a lot. He's one of those people that most off-duty guys that are working there know who he is, and we kind of pay attention to make sure he's not driving, because he gets pretty intoxicated there, and it's just it's a usual thing. It's not it's pretty regular how much we saw him up there with the ladies and stuff like that.
But when you would, and how often would you work that detail? I know you had your regular job, and this would be one you would work in the evenings or afternoons, is that right?
Yes, ma'am. If I was on day shift, I would work this almost 1 or 2 days weekend, either a Friday, Saturday night, or a Thursday, Friday, stuff like that.
And each time you were there, did you see, was Mr. Wiley present at the bar?
Not each time, but he was there more often than none.
Okay. He would be classified, I guess, as a regular, is that right?
Yes, ma'am.
And did you see him oftentimes when he would drink, did he drink to excess?
Yes, we're always worried about how he was leaving.
And did you observe him there, and would his stay be, come in and have a beer and some nachos and go home, or was he there for extended periods of time?
Hours on end. Yeah, definitely.
And have you personally seen him get into a vehicle after drinking?
I've not personally seen him get into a vehicle. The only reason why is that establishment's really busy, and just so happens timing. I come back out and all of a sudden he's gone. It's just random.
And I think at one point in time, you gave a statement to them that you remember your statement, 4 or 5 beers an hour along with a mixed drink. Is that his custom and practice? I think we may have gotten frozen there for a second.
Hello, I'm sorry. I couldn't hear that question. I think the service was going kind of in and out.
You had provided a statement before and talking about, I think the last time you saw him was around March.
Your Honor, I object to this statement. I haven't seen any statement.
I'll rephrase the
All
question.
right, rephrase your question.
In previous information, would you see when he would drink, how much do you recall that he would drink, and what type of alcoholic beverages would he?
He mixed it up. I've seen him with alcohol. I've seen him with beer. He kind of goes back and forth. And like I said, the only reason why I kind of pay attention to him, he gets kind of loud. And then, like I said, we worry about him driving.
But you yourself have never seen him get in an intoxicated state, get in the car and drive?
Honestly, I have to think. As far as getting in the car, I would have to think about that one. I'm not for sure. There's been a few incidences, but it's been a while ago, honestly.
Again, because this was back before you left the sheriff's department that you were keeping tabs on
Yes,
him.
ma'am.
Correct?
Yes, ma'am.
Okay. And again, just asking, he's pretty regular in his attendance at this one bar, is that right?
Yes, ma'am. Everyone knows him there.
Okay. And I believe that's all. Thank you, sir. Now, his attorney may have some questions for you, okay?
Yes, ma'am.
And you have questions?
Yes, Your Honor. Why are you no longer with the Bay County Sheriff's Office as of January 2024?
I actually have a lawsuit with the sheriff's office currently.
And that's because you were,
There's so much more to dig into, but it was a big cluster, and he was all over the news up there and really lost some cred.
you weren't demoted. Didn't you used to work
No,
in the
ma'am.
SWAT and you were demoted from that because you were planting evidence and being untruthful in your
Not plan-
investigations, not following protocol?
Not planting evidence, and I was also added back to the SWAT team before I was gone. So
And in
no, I
fact-
never planted evidence, and that's
In fact, they were so pervasive, your dishonest investigations were so pervasive, it landed you on the news, didn't it?
yes, but also there's evidence that came out that will be addressed in court that provides a lot of more context to that. There's a lot more to this than the news thing. They jumped the gun on that one.
You were dropped from the
We,
SWAT and the U.S. Marshals Task Force, isn't that true?
I was added back to the SWAT team.
And you were transferred out of drug investigations and back to field services, weren't you?
Yes, ma'am.
And that's because of the the numerous violations and dishonesty and the
It
planning.
was not, no, ma'am. No,
And that's
ma'am.
why you're not with Bay County Sheriff's Office today, and you're at EMS now.
And that's why there's a massive lawsuit against that.
Okay. Nothing further, Your Honor.
Anything?
You've been truthful in your testimony today,
Yes, ma'am.
and were you did you quit or were you fired?
I was fired. We have a wrongful termination lawsuit.
And you have sued them civilly for wrongful termination, is that correct?
Yes, ma'am. Amongst a lot of other things.
Among other things, and that is a lawsuit.
Yes, ma'am.
Is it pending in federal court or is it in civil court there? I mean,
It's in civil. It's in civil court.
Florida local court. Yes, thank you,
Yes,
sir.
ma'am.
Thank you, appreciate it.
All right, we're done. Hold on a second. Mr. Williams, we have another question.
Yes, ma'am.
So, Mr. Williams, you even admitted, I can't say what you said because it's inappropriate to say in this honorable court, but you said you effed up. You admitted that to in your internal affairs, that you effed up. It's in the statement,
Well,
correct? You said that.
I don't know what part of it was a massive internal investigation. There's a lot of things that was in play. So that could be
Your Honor,
in
I'm
reference to tactics.
not in evidence, and I have not seen any such report that she's talking about. I would ask to be produced immediately so that I can have access to what she's questioning the witness about. May I please have it?
We've got a copy of that.
We have an objection, Mr. Williams. I'm going to let them address the issue and then I'll come back to you.
Yes, sir.
So I object to hearsay.
Your Honor, these are his words. I'm not stating.
It's not hearsay if it's his statement. Overrule the objection. Repeat your question, please, ma'am.
Yes, Your Honor. Isn't it true that while you were investigated for your dishonest acts,
And again, Your Honor, I'm going to object as to assuming facts not in evidence.
Sustained.
were you investigated by the Bay County Internal Affairs during the time that you were investigating Mr. Wiley, were hired to investigate Mr. Wiley?
Honestly, I don't recall.
You don't recall?
I don't recall. I
You just
don't.
said you've been fired from Bay County Sheriff. So why did they fire you?
Because of allegations. If it was allegations.
What allegations?
Allegations of being
And your
dis-
objection is to assuming facts not in evidence. The document that she's provided me is a document from 2022.
Well, Your Honor, this is a 2-year-old case. It's relevant. And my questions are, while you were being investigated by Bay County Sheriff's Department, you were demoted, and so you were
was not demoted.
hired to investigate
Hold on,
Mr. Wiley?
Williams. Overrule the objection. The question that she's asking is that why was he terminated, if I understand correctly? And he says for allegations, and she was asking him what were the nature of the allegations. So I will overrule it because it's not assuming facts and evidence. It's just allowing him to answer what the answer would be. So you may answer whatever the allegations were.
They didn't like the way I answered a question in a deposition.
Because it was untruthful, isn't that correct?
It was to the best of my knowledge. And like I said, there's a lot more facts pertaining to this. If I would have did everything they're saying that I did, I would have been in jail.
What were they deposing you for?
It was a narcotics case.
Okay, so it was a narcotics case. Who was deposing you?
Well, the defense attorney?
The defense attorney? And so were you, what's the lawsuit involving?
Whose lawsuit? Mine?
Well, in the deposition that you were in, what lawsuit was that?
It was not a lawsuit. It was a criminal investigation.
A criminal investigation?
Or it was a deposition in reference to some charges.
Some charges against who?
A drug dealer.
Okay. And so Bay County Sheriff's Department fired you because they didn't like how you responded in the deposition. Is that what you're saying?
I got fired. I got fired for a policy violation. A policy violation.
What was the policy violation?
Conduct unbecoming.
Okay. And did they give you any more detail as to that?
Well, more detail as it's literally how I answered a question.
Because did you lie under oath? Is that what you did?
The way I answered the question was not to their liking.
How'd you
And I
answer?
answered it to the best of my ability.
Okay. How did you answer the question? What was it that they didn't like about you in the way you answered the question?
I guess you have to ask them. I don't know what they didn't like about it, but I mean, that's something that my attorney and all them are handling right now.
And they've investigated.
There's a lot more.
Bay County Sheriff's Office
Good.
has investigated you multiple times. Isn't that true? If we were to subpoena the Bay County Sheriff's Office today and produce that, it would show that you've been investigated and found to have been untruthful on multiple investigations.
Objection,
Isn't that
assuming
true?
fact-
No, I'm asking the question, Your Honor. If we were to
Hold on, let me hear
subpoena.
what the objection is, first of all.
Your Honor, the way, she has not phrased the question. She has made statements stating, you have been investigated numerous times by the Bay County Sheriff's Department. You have been found to be untruthful. You have done that. It's not, the question is, one at a time, have you been investigated numerous times? He can answer that. Has he been found by anybody to be untruthful? He can do that. But making these blanket statements,
Your objection is basically assuming facts and not in evidence. In other words, you're making a statement that's not in evidence instead of asking the question. Sustain the objection as to the form of the question.
And Your Honor, I asked the question, and so I'm asking, if we were to subpoena this as newly discovered evidence post-trial, and we were to subpoena this, his testimony today would still be, I have never been investigated by Bay County Sheriff's Office for violating protocol and being
objection,
dishonest.
Your Honor.
That's not what he said.
That's-
Not what he said at all. He said basically, in answer to your question that he was terminated, he did admit that there was an investigation, but he was not sure of the timing of it. Your question was he ever under investigation? Was he under investigation? Well, actually, you were saying, isn't it true you were under investigation by the Bay County Sheriff's Department while he was hired to investigate and surveil your client? And that's what he said, I'm not sure. He wasn't sure of the timing of it, the way I took it. Not that he was denying that he was under investigation. If you want to ask that question directly, has he been under investigation, then please answer.
Okay.
Ask that question and
Okay.
let him answer.
Mr. Williams, have you been investigated by Internal Affairs at Bay County Sheriff's Office?
Yes, ma'am.
And they've had findings against you, isn't that true?
Yes, ma'am.
And those findings are that you planted evidence.
Again, you're stating things, asking a question. Even on cross-examination, you must preface it in the form of a question rather than make a statement of some evidence that's not been admitted in court.
Okay.
And then, so that's why it's being objected to, is assuming facts not in evidence. You're making a statement about something that's not been brought before the court, and rather than asking the question about what was their finding, for example.
Okay. What were their findings?
In reference to
The Internal Affairs investigations.
which one? There was two.
Okay. So you've had two internal affairs investigations. Okay, the first one.
Back in. That's when I moved back to the road, out of narcotics.
Okay, what were their findings?
They had it was using an undocumented CI and non-proper storage of evidence,
Okay, and then
or something like that.
the second internal investigation?
The second internal one is the one that's wrapped in the lawsuit.
Okay,
And that was, hmm,
and that was, go ahead,
and that was the one in reference to the statement.
the statement you made under oath.
Yes, the way I answered the questions in the deposition.
And do you recall telling Internal Affairs that you effed up?
Ma'am, these investigations were really long, so I don't know which part of that I was saying that to. Like I said, it was pretty thick binder, so I don't really know what part that would have been in.
And why were the binders so thick? Was it because it was multiple cases for which you
No,
were
it's
engaged in wrongdoing? Or was it one
Objection-
isolated case?
Objection, Your Honor, assuming facts not in evidence, making statements, there's no.
I'm asking, was it more than one case or?
Well, if I could rule on the objection.
Yes, Your Honor.
The objection is overruled. I think she's phrased it in the question, why were the bindings so thick? Were there more than one case? And that's a question she can ask.
And again, Your Honor, my objection was to her because of your numerous wrongdoings. There's been no evidence. And that mine was just to that one statement, Your
I
Honor.
sustained it as to that one statement. If you'll restate your question.
Why was the binder so thick, sir? Was it because there were multiple cases that you had worked that were being investigated? Is that why it was thick?
No, it was just there's a lot of when we do paperwork in cases, there's a lot of paperwork, a lot of evidence. Everything's included in one binder.
So your testimony under oath today that you have, it wasn't just, it was just one case. It wasn't multiple cases in which you were found to engaged in wrongdoing.
Which I was found to in wrongdoing. Ma'am, I don't even understand what you're asking. If engaged in wrongdoings. What do you mean?
Well, stating, for example, here's an example. Have you ever, in one of your investigations, said that a particular item did not test positive for drugs when actually it was positive for meth or fentanyl or something like that?
Now, you're asking
Yes.
an open question about some hypothetical situation that may or may not have ever, and it seems to me that that's far beyond where this would be relevant to this court's proceeding. If it relates to one of the cases that you've already touched on, that's one thing.
It does, Your Honor.
Then ask it in relation to that, and he can either answer it or choose not to answer it if he's got a pending lawsuit, but
Okay, in relation to one of your investigations, isn't it true that Internal Affairs found your statements, your reports would provide that something did not test positive for drugs when it was positive for drugs? Isn't that true?
I have no idea about that at all.
The fact of the matter is, you are not an honest person, isn't that true?
No, that is not true at all.
Known to not be honest.
That is not true.
I'm sorry, what was that question?
You're known not to be honest.
And-
Again, I object to the form of the question and
Number one, it's not a question, it's a statement, and I sustain the objection.
And as to the deposition that caused you to lose your job at the Bay County Sheriff's Office, it's because you were being dishonest, isn't that true?
Ma'am, like I said, those are allegations. And again,
I'm not saying
there's a
whether
lawsuit going on because of that.
again, she is asking whether it's true because that was her content. It's
Your
true
Honor.
that you lost your job because you're dishonest. That was
Can I
her question.
finish? Can I finish without being
She's got an
interrupted?
objection.
Objection, form of the question.
Her objection occurs during the questioning, and therefore we stop the questioning in order to consider the objection. Now you can respond if you'd like.
I'm not saying whether you were honest or not.
Do you have a response to her objection?
Oh, a response to the objection, Your Honor, is not, that's not what my question was. I wasn't able to finish my question before I was interrupted with an objection. I didn't even get to finish my question.
All right, ask the question again, please.
So the question that I was asking is, firstly, you were terminated. Your testimony today is you.
Objection, asked and answered. Ask
Your
and
Honor, I
answered.
just need to make some
Let's
clarification.
let her ask the question before, Mr. Williams, do not answer until I rule on an objection that is forthcoming. But
Yes, sir.
Ms. Burton, if you will ask your question, Ms. Roberts, let her finish the question, and then I will rule on your objection.
You were terminated because of something you said under oath in a deposition. Isn't that true?
All right, the objection is asked and answered, and I sustain the objection.
Your Honor, I have nothing further.
Anything further from you, Ms. Roberts?
Officer, was the time you surveilled him in
You're gonna have,
March?
for him to hear you, you're probably gonna have to come to the microphone.
The time that you saw Mr. Wiley, the reason we've got you here was that in March of last year?
Yes, ma'am.
Okay, thank you, sir, appreciate it.
All right. Thank you, Mr. Williams. You are released from our hearing, and you may go about your business, sir.
That's our proof, Your Honor.
All right, the defendant has rested their proof. Does the petitioner have any rebuttal proof you wish to offer?
Your Honor, may I call Mr. Wiley to address some of the claims that were made against him by Mr. Williams there?
Well, yeah, I would remind you, you remain under oath, but you come back to the stand.
This will be good. Mr. Wiley, how often do you drink mixed drinks?
Never. I'm not saying I've never drank a mixed drink, but I stick to beer, as previously said. I
And-
don't like hard liquor. I stay away from. I stay away from that.
This, I forget the name of the restaurant that Mr. Williams testified about where he saw you. What was the name of the restaurant?
It's Patches. I'm
Patches?
friendly, and I've talked to him as well, not knowing I was being investigated.
And you heard him say that you're there all the time.
Weekends, I believe is what he meant. I'm not there I'm not saying I'm never there weekdays, but on the weekends, I go there once a week to eat. I did. I haven't been there in a while. Renee frequents that restaurant, so I
Okay.
haven't been there.
I have nothing further, Your Honor.
All right,
No questions.
thank you, sir. You may stand down. You have any other witnesses?
No other witnesses, Your Honor, for petitioner.
I'm sorry?
No other witnesses for us.
All right. Ms. Roberts, do you have anything else?
No, Your Honor.
Then I will hear you in argument.
Your Honor, we have a case here where we've got a decorated war veteran who filed this petition when this baby was 3-4 months old, if I can recall correctly. And this case has gone on for 2 years. He still has never had any criminal convictions. He has been charged with something since we filed. But he's an upstanding American citizen with no criminal history. And he's raised 2 children that are now adults. One doesn't like him. It's disputed as to why she doesn't like him. She would like to state that he's a very abusive person. But Mr. Wiley submits through his text messages that it's not about that, it's about money. That's really why she doesn't like him, because he won't give her money every time she asks. I'm sure that well, I'm not going to say that. We have a mother here who has testified that she believes Mr. Wiley should have supervised visits. She knew Mr. Wiley when he was a parent to young children, and she chose to make a baby with Mr. Wiley. But when he broke up with her, because as Mr. Wiley testified, he couldn't bear to see her smoke while pregnant with the child, her revenge is, well, you don't get to be a dad because you broke up with me while I'm pregnant with your child. So we have best interest factors. We're not asking, Mr. Wiley's not asking for custody. He just wants to be a dad to this child, and this child deserves a dad. There have been questions as to whether he's an alcoholic. Mr. Wiley's testified that he doesn't drink hard liquor. He may drink beer, but he hasn't had any. His wake-up call was the incident that occurred with his now ex-girlfriend. The state of Tennessee, the policy behind the state of Tennessee is that a child should have maximum time with both parents. Mr. Wiley would like to have joint physical custody. He would like to have substantial time with his daughter. He's been deprived of that for her entire life, and she's going to be 3 years old soon. And so as far as the best interest factors, he's not been provided an opportunity to have primary care, to be that person to provide for the child and take care of the child. But the mother, I think this court should take into consideration that this mother has interfered with this child having a relationship with the father, and that should be something that's looked at as to why some of these factors now weigh in her favor. Do they really? When we look, some factors should be given more weight than others, and one is the willingness and ability to facilitate a close and continuing relationship between the child and both parents. And the mother has failed at that, to the detriment of this child's future. Mr. Wiley had joint custody of his younger children, and his testimony, which was undisputed, is that when the children were with him, they made excellent grades. They were in advanced classes. They were doing great. They were thriving. But then when they'd go and live with the mother, primarily, not so much. They went to online schools and had problems, the daughter at least. Now, Mr. Wiley's son, who he continued to have primary care of, is on track to, don't know all the words for, what path he's on militarily, with regard to his military career. I'm not a military expert, but Mr. Wiley testified that he's in flight school, and he's going to go to medical school after that. So it shows that Mr. Wiley is a good father. The child that did live primarily with him for the duration of his childhood is on a great path to a bright future. The one who didn't has got mental health issues and drinking problems and drug problems. And so we're just asking today for Mr. Wiley to be allowed to be a dad, and for Anna Claire to be allowed to have a father. And that's what we're asking for, Your Honor. Child support is what it would be based on the guidelines. We've got the income. We don't dispute what the testimony was that came out as to what the parties' incomes are. We do ask that the child's birth certificate be changed, and that evidence was presented on our first day of trial. We asked mother questions about that, why she named the child what she did on the birth certificate, and Mr. Wiley testified that he would like to have his name on the birth certificate, so we're asking that the child at least have a hyphenated last name. And that's all we have, Your Honor.
Roberts?
Your Honor, I'm going to address the name change first. Your Honor's well aware of the law in the state of Tennessee, and I would cite you to the case of Lockhart versus Higgins, which was decided by the middle section in July of 2021. In order to change a name, statutorily, when a woman has a child out of wedlock, the child's name shall be that of the mother's. And then a non-marital parent can ask for it to be changed, and there is the 5 factors that the court has to consider. In order to change a child's surname, unless you have to prove, the parent requesting the change has to prove that the change promotes the child's best interest. Among the criteria for determining whether a changing of a child's surname will be in the child's best interest are: 1, the preference of a child, the change's potential effect on the child's relationship with each parent, the length of time the child has had the present surname, the degree of community respect associated with the present and purposed surname change, the proposed surname change, the difficulty, harassment, or embarrassment that the child may experience from bearing either of the present or the proposed surname. In the case that I cited, Your Honor, it was a matter before the court, and the court granted the father's request for a surname. It was appealed, and the Court of Appeals went through the evaluation on the standard of review, and stated that the legislature has established a policy in this state that if a mother was not married at the time of either conception or birth, or between conception and birth, the surname of the child shall be the surname of the mother. Subsequent to that, a child's name can be changed upon a showing of best interest, and that has to be a substantial showing that when a biological father is seeking a surname change, the proof established is not insubstantial. In the case that I'm citing, a thorough review of the record in this case shows that the father presented no evidence that changing the child's surname would benefit the child. Father further stated the only reason he wanted the child's name changed was because he might want to coach him in sporting events at a later date. It's a general statement or opinion or belief is not sufficient to establish the changing of the child's surname is in the best interest of the child. Rather, such statements merely focus on how changing the child's surname would be in the best interest of the parents, not the child. And in that, the court overturned the trial court's ruling because it said that the father did not present any proof of the 5 factors or any other factors proving that a change would be in the child's best interest. So we would respectfully request that you deny a surname change. Now, this petition was filed in June of 2022. My client, on behalf of my client, I filed an answer, and the first thing we did is we admitted paternity. It was not a question. We admitted paternity in both the answer and in the amended answer because they filed an amended petition, and we admitted paternity. They filed a motion for temporary residential time, and they came in and questioned paternity and asked for a DNA test. We admitted that that was fine. We could do that, and the case was continued to allow that. The DNA test was done. I arranged for that to be done before he left the area, and they went the next day after court to do the DNA testing, and we both received it. And at no point has there been any request to change the birth certificate to list the father as the biological father. And now we have no problem with the birth certificate being registered. He's the Judge, that he is the biological father, and we have no problem with that being done, but we do object to the surname being changed. Once that is done, again, the court order can put down, we don't dispute that the parent-child relationship should be established. But what the factors are in this case is that, and again, I almost think we were hearing 2 different cases. Mr. Wiley's intent is to be a father on his terms, not on the child's terms. We submitted 2 huge notebooks of even before when she found out that she was pregnant and these people were not going to be together. She has kept him notified of doctor's appointments. She has provided photographs. She has invited him to come visit. And in the meantime, he retired from the military. He was living in Alabama. It's interesting to note that he testified that his home state was Tennessee. She is from here and in this community. When he retired from the military, no fault on him electing to go live at the beach. We were all probably a little bit jealous of that fact. But the fact is he wanted to be a parent as his attorney and he's professed. Why would he not move back to his home state? He's the one that testified Tennessee is his home state. Why would he not back to be here so he could be a day-to-day parent for this child? Because he did not want to be inconvenienced. He wants to be a father to this child, but he wants it on his terms, not the child's terms. And luckily, what this court is focusing on is what is in the best interest of this child. And my client has made, although they said texting and FaceTiming and doing all that is somehow a negative in their book, but my client has made every effort to keep this man informed, inviting him to the home. Does she want the child to go down and go week to week? Absolutely not. This is a young child and it's not appropriate. And again, this case has been pending for 2 years. At what point in time after he retired from the military did he put a fence in his backyard? Did he take what he testified to, I can take an impact wrench and put some plywood up and it's fine. When did he do it? He's had 2 years, 2.5 since the child was born. Over a year since he's been retired. When is he going to do it? He's not, because he wants to leave the life of leisure. Wonderful. Go be a boat captain. Go be a dive steward. Go to the Patches and drink every day. That is great. But if you really wanted to be a part of this child's life, then do something. Get your house ready to do it. Come up here. This man professes, oh, I'm just barely getting by, I'm doing this. He says he's got these homes and that he's had nothing but leisure time, but he hasn't been able to renovate any of them. Again, because he's living on his time, and that's what he wants to do. So secondly, they didn't dispute the income informations, and I wanted to make sure that we put that in there. Judge, according to even though you told us to produce that information, and his veracity and his character is significantly at issue, taking that income and expense statement and things that he did, he is making, if I add it correctly, he is making $6,200 from his retirement, $4,313 from his disability. He has one rental available at $1,200 and another rental that he brings in $1,850. His monthly income is $13,566. He should not be given any credits. He's for any type of insurance or work-related daycare. And so his base is $13,566. He has no support obligation or afterborn or beforeborn children, so that's it. My client has testified that she works 6 shifts at Horizon at 6 hours, so that's 36 hours at $75 an hour. She works 1 shift at Centennial, which is an 11-hour shift that she works for $75. And she works 2 shifts at the emergency room at Nashville General. So that's an 18-hour shift for $76 an hour. So her monthly income is $4,893. She pays work-related childcare at $13 an hour for those number of hours that she works. And she should be given credit for that. She is maintaining health insurance on the child and should be given a credit for the cost of the health insurance. She's testified undisputed that the child's doctor does not take TRICARE, so she would have to keep that anyway, so TRICARE would be the secondary insurance if he decides to put the child on TRICARE. And so those are the issues on, I think that we have said on that one is undisputed, and those are the incomes. So next, the court is going to look at 36-6-106 and the factors. The strength, nature, stability of the child's relationship with each parent, including whether one parent has performed the majority of the parenting responsibilities relating to the daily needs of the child. That's obviously weighted heavily in the favor of my client, the mother. Each parent or caregiver's past, potential, and future performance of parenting responsibilities, including the willingness and ability of each of the parents, caregivers to facilitate and encourage a close continuing parent-child relationship between the child and both parents. You have notebooks set out where my client has attempted to get this man involved in this child's life, and he wants to do it again on his terms. In determining the willingness of each parent or caregiver to facilitate and encourage a close continuing parent-child relationship between the child and both of the parents, the court should consider the likelihood of each parent and the caregivers to honor and facilitate court-ordered parenting arrangements and rights, and the court shall further consider any history of either parent or any caregiver denying parenting time to the other parent in violation of a court order. There's not been a court order established, but my client has offered time, and he has, and again, justifiably, sometimes he's refused it, but he has refused it. Refusing to attend a court-ordered parenting seminar, my client did do it. I haven't seen in the file where Mr. Wiley has done that. He may have, but I have not seen where it's been filed with the court, and if that's been done, then I just have not, it's not been provided to me. The disposition of the parents to provide the child with food, clothing, medical care, education, and other necessary care, clearly on the side of my client. The degree to which parent has been the primary caregiver, again, my client. The love, affection, and emotional ties existing between each parent and the child, again, if Mr. Wiley had come up and spent considerable time, that would probably be an equal factor. But the fact of the child's love, affection, and emotional ties, it clearly sides on my client because she's encouraged that with him, made the phone calls, made the contact. The emotional needs and development level of the child, that's the factor that the court has to consider in the environments of the two parties. Obviously, Mr. Wiley is a retired military, and he wants to live his days out fishing. And that's a wonderful thing to do. But again, he has a 2, almost 3-year-old child. Those lifestyles are going to have to change, and for all evidence, he's not planning on doing that. He wants the child to adapt to his lifestyle, not him to adapt to the child's lifestyle. The moral, physical, mental, emotional fitness of each parent. Again, we have put on disinterested individuals talking about his propensity to hang out in bars and to drink and party, and he's been charged, albeit not convicted, but he's been charged by his longtime girlfriend of a domestic assault with a weapon. And again, that's quite concerning. The child's interaction and interrelationship with siblings and step relatives. My client is the one that's instigated the brother and the sister coming in and to have a relationship with his child, not Mr. Wiley. The importance of continuity in the child's life, obviously a factor on my client's side. The evidence and physical and emotional abuse of the child or the other parent, that's not a factor. The character and behavior of any other person who resides in or frequents the home. Again, the one person that Mr. Wiley frequents at his home is a woman who either he's physically assaulted or who has manufactured false charges, but they're both out partying and drinking all the time, where you're having to, at the next day, you're taking boxes of beer and other stuff out of the house. Each parent's employment schedule. Again, he's not employed, although I think he is employed. I think he just lied. I mean, he's taking people out, he's doing things like that for pay, he calls it splitting gas or whatever. But again, I think you can take his testimony for what it's worth, and that's a big 0. And any other factors that the court deems appropriate. Again, their parenting plans have stated that she is the primary, so that's really not on contest either. What we're asking, Your Honor, is that this man have an obligation to come up and form a relationship with this child, that he comes up monthly, that he comes and he visits with this child. And that at the point in time that this criminal case, I'd ask the court, I hate to do it, but I want to see what happens with this criminal case. I'm getting the transcript. I've been in contact with the prosecutor in Bay County to provide them copies of what his testimony when he attempted to take his Fifth Amendment right, but then didn't. So again, I want to see what happens with that and whether he's convicted of a felony charge. And then once that happens and the child gets older, he makes some type of concerted effort to get his home ready to have a toddler. That would be the only time that the court considered that he has residential time in Florida. Do I think he should have supervised visitation time? My client testified she'd like to be supervised, but I think there's no problem with he can come up here and get a hotel room and visit with his kid. And can go and do things, and there's Airbnbs all around that has the availability that he can come up and spend extended periods of time with this child, and this child get to know who her daddy is. But he's just not willing to do it. He wants everybody to accommodate him, and he's not willing to accommodate this child, and that's the whole crux of the situation, Your Honor. Thank you.
There are days when I wish I didn't have this job, and today is one of those days. This is not one of those cases that's easy for this court to decide. On the one hand, we have Mr. Wiley, who has served his country honorably and has a lot to be proud of in that regard, and obviously Ms. Burdine has brought that to the court's attention several times. However, being an honorable member of the military does not always make you a good parent. And my responsibility is to balance the rights of the parents with the best interest of the minor child. The case law in every child custody case that's gone up on appeal has always been that the poll star, the primary interest that the court has in a custody battle is to determine the best interest of the minor child. And sometimes that best interest of the minor child works in the best interest of the parents. Sometimes the best interest works against one or more of the parents' best interests. So therefore, it can't always be that one side feels like they've won something and the other side feels like they've lost. So first thing in this court is to establish paternity. Both sides are in agreement, as Ms. Roberts pointed out. Ms. Winters has acknowledged that he is the father of the child. He requested the DNA paternity testing. It has been done and performed, and it does show him to be overwhelmingly the father of this child. So he will be found by this court to be the biological father of this child, and paternity is established. Then it becomes the issue of the court having to adopt a parenting plan, and the primary purpose of the parenting plan is to not only to set the residential schedule, but to determine who should be the primary residential parent. Mr. Wiley would like to have equal residential time, and Mrs. Wiley is resistant to that idea. So I'm required to look at 36-6-106 of child custody. Before I do that, let me address the issue about the name change. As was pointed out by Ms. Roberts, and by which this court is well aware, that there are certain statutory factors that have to be met for the court to determine that a child's name should be changed. It is not sufficient to say that the father's desire alone to have the child's name the same as his is in fact a basis alone that would justify the change of the name. So this court's of the opinion that none of the proof in this case has substantiated or met those statutory and case law factors that were set out by our appellate courts and adopted by the appellate courts to justify the name change, and therefore the name change request is respectfully denied. So we move then to the issue of the child custody, and we look at 36-6-106 in the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed majority of parenting responsibilities relating to the daily needs of the child. Clearly, in this particular case, no matter whose fault it is, that clearly the facts have established that Ms. Winters, the mother, is the parent who has performed the majority, if not all, of the parenting responsibilities relating to the daily needs of the child. Mr. Wiley has come up and visited the child, but other than that, other than those short periods of visitation, then he has not really been involved in it. And I'll address those reasons that have been raised by Ms. Burdine in her argument. Each parent or caregiver's past or potential for future performance of parenting responsibilities, including the willingness and ability of each of the parents and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, consistent with the best interest of the child. Now, I understand that Mr. Wiley says that she has prohibited him, and perhaps Mr. Wiley thinks that he should have been allowed to just pick this child up as an infant and take the child to Florida and keep the child for 50% of the time. I don't think he really thought that. Nor do I think that when the child was a year old that he perhaps thought that. So I think the argument is that he doesn't think he's been given enough of an opportunity to provide care for the child or to have a reasonable visitation schedule. And he believes through his lawyer that Ms. Winters has been the reason for that. I disagree, and the finding of this court is that Mrs. Winters has, I see these cases day in and day out, and I can tell you that I recognize when a parent is trying to end or terminate or prevent a meaningful relationship with the other parent. I see it all the time. There's nothing in this case to justify the argument that Ms. Winters is trying to prohibit or keep him from having a meaningful relationship. If that were the case, she would not be calling him for FaceTime visits. She would not be trying to set up visitations when a court hearing. I understand it's not easy to visit when it's your ex and you're having to see your child under that person's supervision. But I do not find that there is proof in this case that would justify the finding that Mrs. Winters has in any way tried to prohibit him from having a relationship. It's a two-way street. Highway works both ways between here and Panama City. And I've driven it enough times to know it's a long trip, but you can make it if the reason for your trip is urgent enough and important enough. Refusal to attend a court-ordered parent and education seminar. I don't know that I've seen the certificate from Mr. Wiley, but if he has not already done so, he will do so within the next 60 days. Mrs. Winters has shown that certificate to the court. The disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary means. Clearly, Ms. Winters has been the person that's primarily done that, and she has been the one who has provided him with food and care. I believe the testimony was that the only support Mr. Wiley has given were a couple of checks that total up some $2,000 or so, and that's hardly sufficient support for a child, no matter if the child is only 2 years of age. So she has been the one who has been providing support for this child. Disposition of each parent, I've just touched on that, sorry. The degree to which each parent has been the primary caregiver, and I've already touched on that. Mrs. Winters is clearly that parent that has been the primary caregiver. The love, affection, emotional ties existing between each parent and the child. I don't have any doubt that clearly Mrs. Winters is very attached and close to her daughter. I think Mr. Wiley also has great affection to it, and he's for the child, and I think that demonstrated by the fact that he has consistently tried to bring this matter before the court and trying to get some additional time with his child to have a normal relationship. There's no evidence to the contrary, and I do find that there is love and affection and emotional ties between him and the child. Problem is, of course, that the distance factor. Emotional needs and developmental level of the child. The child is 2.5 years old. I have some experience with 2.5-year-old children. I have 2.5-year-old children that are grandchildren of mine that I deal with. And there is an emotional need for regular contact between a parent and the child, especially at that age. You cannot expect to have a good bond with a child unless you're given an opportunity to see that child regularly. And the biggest factor in your case is your distance. One of the biggest factors anyway. The distance factor between the two of you is one of the major impediments to what is taking place. The moral, physical, mental, and emotional fitness of each parent as it relates to their ability to parent the child. The court may order an examination, which I see no reason to do that. Therein, I find no evidence that indicates that Mrs. Winters or Miss Winters is in any way suffers from any sort of problem. Problem is that there's been an abundance of proof that Mr. Wiley has an alcohol problem. And as one of our judges used to tell me when I have a case before him, if you've got an alcohol problem, if alcohol is causing problems in your life, and under the circumstances, I applaud Mr. Wiley if he has in fact quit drinking after this last episode that led to him being arrested. But the fact of the matter is that he has a pending felony criminal charge that is still ongoing. He has not been convicted. He is presumed under our law to be innocent of that. But if you heard his testimony on day one of this trial back on June the 9th or whatever day it was that we were here, he admitted to a lot of what would probably going to be enough evidence to convict him in some courts. And that is, he admitted that when she grabbed his arm, that he wrestled with her, grabbed her around the neck in a chokehold and held her there and hit her in the head 2 times and then forced her back, and she fell and hit her head against something. He also testified that when she came back in that, he drew a weapon on her and told her that he had a weapon. He denies he pointed it at her. But that testimony, and I made a note, I advised Mr. Wiley that he had the right to invoke the Fifth Amendment and not to incriminate himself, not to testify about any of those factors. And he invoked that Fifth Amendment right at one point. But he could not control himself, and it became one of the worst invocations of the Fifth Amendment rights that I've ever seen, because he basically then testified about what I think would be sufficient evidence. Even after initially invoking the Fifth Amendment, he then went on to testify about what his actions were and how he felt justified in them. And that may well be. In Florida, he may well be justified in doing it. But, as one of our other judges used to say, confession may be good for the soul, but it never saved a marriage or kept a man out of prison. So I hope that testimony you gave does not turn out to be the undoing of your criminal case. In any event, he has that case pending, and as a result of that, he is, in my opinion, got some issues that are going to have to be dealt with, and I base that not on the fact that it's just that he has a pending charge, but rather his own words from the testimony that he gave are what I am basing that upon. In addition to that, number 9, the child's interactions and interrelationships with other siblings, other relatives. Basically, I don't have a lot of evidence on that point other than Miss Winters has allowed or has engaged in allowing one of the minor child's, I guess it would be her half-sister, to become involved, Ashley, and become involved in her life. the importance of continuity in the child's life, clearly, and the length of time the child's lived in a stable, satisfactory environment. This child has lived with Miss Winter from the day of her birth until now. She is in a stable environment, is everything that I hear. There's no evidence of her being an abusive or neglectful parent, and therefore that factor obviously factors in her favor. Evidence of physical or emotional abuse to the child, to the other parent, or to any other person. This is where Ashley's testimony is disturbing for the court, because Ashley, as we can make the argument that we have children, and you raise those children, and therefore he's a parent that has experience in raising those children. And sometimes, sometimes it turns out that our children do exactly like we want them to be, and they turn out to be exactly like we want them to do, and they do everything we want them to do. And then once they become a little older, they have a mind of their own. How you deal with those difficulties is a different matter. And I made mistakes as a parent when my children were younger that my children and I talk about sometimes. But the fact of the matter is that as a military parent, you may believe that putting your children on their knees in the corner with their nose in the corner and then playing music, as Ashley said, for 12 hours at a time, a loud song, those are types of behavior that you might see at Guantanamo Bay. It might be something that would be acceptable under different circumstances, but for minor children, that's unacceptable in this court's opinion. Now, especially when Ashley says that when, she resisted, that he smashed her face against the wall. Mr. Wiley says, no, I didn't smash it against the wall, but I did turn her head back to the corner and point her nose in the corner. And, sometimes people can take that wrong. Well, it tends to, again, go to the issue of credibility. And I will say that every one of these factors that I'm factoring in and every decision I make in this case is at least factored in on credibility, based upon the credibility that I judged between these parties. And frankly, I find Ms. Winters to be a credible individual, and I have very strong issues with the credibility of Mr. Wiley. I've given him credit for his military service, but his testimony in this court has been filled with inconsistencies and evasion, and in instances where he was less than sufficient proof of his actual income that would justify that it was in compliance with the court order. But be that as it may, I'll make findings about that. The evidence of character or behavior of any other person who resides in or frequents the home of a parent, the only evidence I have of that, Mrs. Winters has no other individual in her life, according to her. She does have a person who is a family friend that provides care for the child. And beyond that, she does not have a personal relationship. Mr. Wiley had a personal relationship for some time until it dissolved into this criminal case that's been pending, or there is pending, and as a result of that, I think under the circumstances, that probably will not likely be a future relationship, but it does demonstrate that there is some volatility in his personal life whatsoever. Each parent's employment schedule in the court may make accommodations consistent with those schedules. There is no reasonable preference of a child of 12, so I'll skip that one. But Mr. Wiley is not employed per se because he has retirement and disability from the military, and certainly that is justifiable. He talks about taking his captaincy or trying to become a captain, a charter captain, and apparently he may be making some steps towards that. May have already obtained that. He's also set up an LLC, which I'm assuming the LLC may have to do with his, it was never really explained, but the LLC has to do with his, if it does in fact have to do with his chartering service, then so be it. But in any event, all of those factors taken as a whole factor into the fact that this court finds that clearly the evidence establishes that Mrs. Winters should be the primary residential parent of this child. So that brings us then to the other factors that I have to consider in setting a parenting schedule. I want Mr. Wiley to have a relationship. I want him to have a normal relationship and to have a relationship that can allow him and this child to, bond and become a type of relationship that perhaps he and his Ashley did not have, but maybe one that he and his son have. We don't really know. The problem is, of course, that when I hear the evidence of the alcohol abuse and the fact that Mr. Wiley says I've quit drinking, that I take with a grain of salt, because probably he has bond conditions right now that on a criminal case, it's typical that they will assign bond conditions on a felony criminal case that say you cannot assume alcohol, especially if alcohol in some way factored into the situation. I want him to be able to see this child, and we have a 2.5-year-old child. The evidence is that he lives in a home that's not particularly suited for a child to be outside, and the photographs that have been exhibited of that home have clearly shown that the backyard of that home, if I've got it correctly, well, it doesn't matter, that the backyard of that home directly goes down to the intercoastal waterway, and that there's no barrier. There it is. This picture shows that it goes to the backyard down to the water, and there's no barrier whatsoever. And as was pointed out, the back of the house has an open patio and has an open back porch, if you want to call it that, with columns. And while it's been said that you can put up barriers that would keep her from going out, minor children especially are ones that can get away from you in a hurry. So where there's nothing in this evidence to indicate that that is any way protected against a minor child of 2.5 years old sauntering down and falling into the water, even if it's only 5 feet deep, that's sufficient. We see individuals who unfortunately have tragic situations with their children. One occurred not too long ago where a child fell into a swimming pool with a family around them, and they took their eye off of the child and had to do CPR to get the child back. So it can happen, and it can happen in a heartbeat. And so my job is to ensure that there is a way for Mr. Wiley to visit with this child that protects the child. At this time, it is my opinion that, and I will say this as well, that the history of parenting with his daughter, the alleged emotional and physical abuse that Ashley has detailed with the court, the factor of his home and the distance factor between his residence in Panama City, excuse me, and the child's home here in Dixon County, all of those things are, in my opinion, factors that I have to consider. As a result of that, it is my opinion that he should have regular visitation. I understand the distance, but again, and the cost to him. One of the credibility problems I have, excuse me, is the fact that he has all of this property, and that's free of a mortgage. Every piece of property he owns is without a mortgage. That would indicate to me someone who has a fairly significant financial portfolio. In addition to that, the testimony was that he has about 5 boats and 3 cars. So we see kind of where his emphases are. He's acquiring material items, and those items are free of any sort of debt, so he's been using money to do that. Well, now it's time to start using money to build this relationship with your child. So I'm ordering that the 3rd weekend of each month, he will have the right to visit with this child. And for the first 90 days, that visitation will be supervised. Now, I will agree that if Miss Winters is not, a person that's got, if there's a problem between her and Mr. Wiley in that, and she can find someone else who can supervise, then I'd be for that. If you've got a friend or a family member who can stay with him while the child, we're going to start it from for a half day on the first day. It can be morning or afternoon. Y'all work that part out. Communication is going to be required. But I'd say if he comes up for the weekend, I want him to have Saturday and Sunday with the child. And that'll be for 3 months. He'll have the 3rd weekend of each month for 3 months. Following that, he will have unsupervised visitation. And that will continue for, again, the third weekend of each month. And that will be from Saturday at 9 a.m. until, we'll make it at 4, 5 o'clock, 5 o'clock. And that'll continue again on Friday. Let's make it Saturday and Sunday on the third weekend of the month for 3 months. Then we will review this matter on December the 18th. And that will be for the purpose of determining any adjustments to the visitation schedule, the current status of Mr. Wiley's criminal case, and whether or not there are any factors that would justify increasing or allowing this child to go for visit. Eventually, Mr. Wiley is going to have the right to take this child to his home. There's no question about that. But again, even if the child is 5 or 6, it's still the limitations on the home, the safety structure of the home is still going to be an issue. And so I think it's going to be up to Mr. Wiley to determine whether or not he wants to make those improvements and then go from there. And in that 6-month period, we'll see where his criminal cases are, and we'll see how this child is doing with the visitation, the unsupervised visitation, as opposed to that. Unsupervised visitation is not going to be overnight at the present time, but I want to build towards that. And then eventually you can see that that will likely increase to overnight visitation and will, again, continue to be in the state of Tennessee until we can make some determination about these other factors. He will be ordered to pay child support. His income is fixed at the amounts that have been shown at $13,566. Hers is set at $4,833. That's based on the testimony of the parties. And she will be credited for work-related child care. Because he has TRICARE available that is not covered by her child's physicians. Is that Vanderbilt that you take the child to?
It's Old Harding.
Old Harding
Old Harding
Pediatrics.
Pediatrics, same place my children went. That will be the primary insurance, and she'll get credit for that. At this time, child support guidelines require that someone be given credit for overnight visitation or for a day of time with the child when they have overnight visitation, a 24-hour period. At this point, Mr. Wiley does not have that. It will come, and we'll have to make an adjustment, but at the present time, he does not have it. I'm going to reserve the issue of retroactive support until we have that December hearing, and then we'll deal with that on that point in time, and you can follow up with any other information you need regarding income for that period of time. So I believe that I have, and Mr. Wiley will continue to have at least 2 times a week that he can speak with his child by FaceTime video. Apparently you've done a good job of allowing that. So let's let that continue. Is there any issue that I have not addressed?
When he goes unsupervised on Saturday at 9, is it Saturday at 9 to 5 and Sunday 9 to 5?
Yes,
Yes, sir. That's,
because by that time he will have had sufficient time, in my opinion, and we need to get him to where he's got the child away, and for an extended period, he can take the child to the park or do whatever and spend time with the child. And as it turns out that taking care of what will still be about a 3-year-old child, 2.5-year-old child for 9 to 8 hours a day or so may not be the easiest thing in the world to do anyway. So,
yes, sir.
anything else then before we adjourn?